two bad news.
Yes.
One, Bimbasar Dar,
Yes, sir.
Yes, yes.
a very good advocate,
Yes.
government counsel.
He appeared before your lordship.
Yes, I remember. I remember. Yes. Very gentle man,
Yes.
very persuasive.
Yes.
Could not leave the matter so easily. He has passed away. Yes. Oh, untimely death it is.
Yes,
He was
untimely death.
aged also.
Only 61.
61. Maybe little younger to me.
Yes, yes.
Yes, younger to me. Another person is Frank Caprio of American judge, American court. A great judge, very compassionate, very kind, and he was known for sympathy. And I don't have a badge, but I have a heart. These two persons have died. So, 10 seconds.
Yes.
We will do Mauna Charan. Okay? 10 seconds.
Yes.
Yes.
In a pension matter, a person retired since 2022, and in spite of an order passed by the in the writ petition, that order was not carried out. Second thing.
I want to mention, my lord, the petitioner working as assistant teacher, my lord. Now disengagement. Your lordship has issued notice in this matter. Now the director has been taking steps to fill up, my lord. Can take out tomorrow, my lord.
Tomorrow.
Well,
We'll have it next week. Immediately it will not be filled up.
Well,
It will be cut off.
already direction has been issued by 29/5/2025, my lord.
Okay.
Oblige, your lordship.
This is a common matter.
If we can have it Monday.
Yes, my lord. Oblige, your lordship.
Matter relating to allotment of GPF account number. This is a common matter. So
It will
kindly
matter.
come.
Next week.
Next day regarding the report of security, this is a matter, my lord.
After week after next, we can have that.
My lord,
Week after next.
next week, my lord.
Well, this is a fresh admission matter. Well, the petitioner filed a writ application challenging the illegal action of the opposite party, despite the proposal sent for the reconstitution of the governing body. Till today,
Posting.
but
You want posting?
I am the managing committee, my lord.
No. Is to be posted before the court.
Yes, my lord. Tomorrow, my lord. Yesterday,
Tomorrow not possible.
my lord, yesterday I have given a memo, but this is a very urgent.
Just
My lord, my lord, fresh admission matter, petitioner's prayer is for regularization, my lord. The opposite parties are taking steps to, my lord, disengage, my lord. Yesterday they have taken a step to disengage them.
have they issued any order?
No, my lord, they have not yet issued, but they will disengage the petitioner, my lord.
2018 matter, my lord. One FO for granting aid matter.
Huh?
Granting aid.
Granting it.
Yes,
All right.
FO, my lord.
My lord, this is a,
From Thursday next, not this coming Thursday. Thursday next.
My lord, this is a matter relating to an IA for early disposal. My lord, if this matter is not heard, 85 tribal students will actually lose an academic year, my lord. May kindly be taken up.
When?
My lord, any short, tomorrow, if possible, my lord, may be taken up.
What has happened?
My lord, 85 tribal students in Mayurbhanj, they were not given admit cards in time for which they could not give their exam. And now the supplementary exam results is also going to be published. They'll lose the academic year, my lord.
Exams are over now.
Exams, my lord, the supplementary exams, we had filed this writ petition to allow them to take another re-examination. My lord, again, all the vacancies with regard to the post will again, the other courses will start in August, my lord, after August. So if this matter is not taken up, they will lose the whole year, my lord.
The petitioner is not getting is the regular salary is going to be retired in years.
When they retire?
They retired in January 2026.
January.
Since 2012,
Give it up to 3 weeks.
pardon to mention,
Yeah.
Pardon to mention, Your Lordship, this is a matter about my appointment as a guest, as a assistant professor. Your Lordship, in the last occasion, Your Lordship had directed that just to serve the pleading to opposite party number 5 and 6.
You have heard it now.
Yes, Your Lordship, but with due endeavors, we are unable to find counsel for opposite party number 5, Your Lordship. So issue notice, Your Lordship. Kindly list this tomorrow.
Next. Okay.
Oblige, Your Lordship.
Yes.
Hello.
Page 1, item number 1 to page. Page 2, 11 to 20.
Item number 18, my lord. I have no instruction.
You have no instruction.
No instruction. Finally, I have already disposed of in the year 2012, my lord. Taken away by the client.
What we should do with that?
I have no knowledge in my files. I really has been taken away by the.
No points. 2012 matter.
12 matter.
But how can if you say no construction, you have to.
I have no instruction. I have no brief.
Cabinet on civil issue court notice to the petitioner returnable within 2 weeks. Since his counsel says that file has been taken and he has no instructions to argue the matter. First, court notice, issue court notice.
Page 3, 21 to 27.
Item 24. The fresh matter, I take committee taken up next week because along with another matter which was filed by the state government, FO, state
Call along with
FO 285 of 25.
25 after 2 weeks.
Next week.
Next week, you have to complete with holidays. Yeah.
Page 4, 28 to 35.
Only 2 persons. Which is your matter?
My item 61.
60. You want sign?
Yes, 61. 1 week after.
61. 2 weeks.
My lord, item 58.
58.
Yes, madam.
23 matter.
Yes, it will.
Sorry. 2 weeks at the request of. 43. You want time?
The counter has not been filed by the opposite party.
Which year?
24.
24. Up to 3 weeks at the request of.
Chief petitioner, sir. Apply का certificate.
You came running.
My lord.
What do you want? A posting of the matter?
My lord, my appeals are pending before the appellate of 5 years, my lord.
Previous.
My lord.
Call it down. You stay. Stay.
Obligation.
Item 1.
May I please, Lordship?
Yes. You have filed the additional affidavit.
Yes, Lordship.
What is this matter about?
Lordship, I am an unmarried daughter, Lordship. My pensionary benefit of my father has not been granted by the...
Benefits of father not granted.
Yes,
Yes, Mr. AG. Why not?
My lords, in fact, some problem is that it was allotted to another friend.
Take up the next step, the request of the AG. A short counter to be filed as to why pensionary benefits of deceased employee are not dispersed to the petitioner daughter. Petitioner who claims to be daughter. Okay.
Item 2. Item 2.
Yes, Lordship.
What? This matter about. Go to prayer.
My lord, covered by Ritanjali Giri, similar matter has been passed by coordinate bench. I am submitting the copy of the order.
Covered by?
Yes, sir, my lord.
That Ritanjali
Giri.
Ritanjali Giri.
Adil Paul versus State of Odisha and Anand.
What in that matter? What benefit is given?
Yes, ma'am. Service benefit.
Leave benefits.
Yes, ma'am.
Any representation is given?
Yes, sir. Representation pending.
Pending.
Yes, sir.
Let them consider in the light of that. In the light of this judgment. Yes. Petitioner, an employee of higher education, he is knocking at the doors of writ court with the following prayers. First, learned counsel, Miss, what's your name, doctor?
Miss Vijay.
You are not vocal.
Kartik.
You should be little louder.
Kartik Kumar.
Huh?
Vijay Lakshmi Sahu. Miss Vijay Lakshmi Sahu.
Petitioner. So argues that similar matters having been disposed of by a coordinate bench of this court, relief is directed to be granted. While Ritanjali Giri Elia versus State of Odisha 2016 1 ILR cut 1162. And therefore, similar benefit needs to be extended to her client on principle of parity and equality. First one. Next paragraph. One more sentence. She also submits that despite her client's representation dated 7/2/2025, a copy whereof avails at Annexure 2, no decision is taken by the OP, Director of Higher Education. And therefore, this court should come to the aid of the petitioner. Next paragraph. Learned AGA having resisted the petition, appearing for the OPs, initially resisted the petition. That the representation is given only in February 2025 and that the authorities should be given reasonable breathing period so that a decision is taken on the said representation. And therefore, petition is premature. First one. Having so contended, now he fairly agrees to instruct the jurisdictional OP to look into the grievance of the petitioner as has been aired in the subject representation in accordance with law if all contentions are kept open. This is appreciable. Next paragraph. In the above circumstances, petition is disposed of. A direction issues to consider petitioner's representation dated 7/2/2025 at Annexure 2 in accordance with law and inform result of such consideration to the petitioner within an outer limit of 8 weeks. First off, it hardly needs to be stated that such consideration should happen in the light of coordinate bench decision in Ritanjali Giri Supra. First off, all contentions are kept open. Next paragraph. It is open to policy. Now, no cause.
Item 3.
Item 3.
May I please, Your Lordship? Your Lordship, I am for the petitioner in item number 3. It is WPC 21972/25. There are 3 similar matters pending before this court. Your Lordship may direct that all these matters may be taken up in the second week of September.
And I am for the petitioner in WPC 17834, which is the second sub-item.
It's a connected matter, therefore all as well as all four.
What is the prayer in these matters?
Also, it is with regard to the attachment of property, with regard to the illegal attachment of properties. It needs a very careful scrutiny by this court, and my senior Mr.
So every case will very carefully scrutinize.
Lordship, I did not. Lordship, my senior Mr. Milan Kanungo will assist your Lordship. Therefore, I pray that it may be taken up in the second week of September.
At the request of counsel for the petitioners, call these matters in week of September, along with WP numbers so and so.
Item 4.
Yeah.
Item 4, my representation for consideration in the light of Ritanjali Giri has been rejected. The Lordship in identical matters and pleased to issue notice.
Issue notice. Learned AGA is requested to accept notice for the respondents. Call this matter along with WP number.
Say, sorry, Item 7.
Any other Gitanjali matter like that? Not. Next.
Item 5.
No. On similar matters, your Lordship has issued notice. This is the matter. Other cases also they have.
Any interim order is granted?
Yes, madam. That is there.
Issue emergent notice. Learned AGA is requested to accept notice for OP numbers.
All the
OPs. First up.
No private OP is there.
Learned counsel for the petitioner presses for interim order, contending that in identical matters already such orders have been issued, and therefore his client should also be extended with the same. First up, prima facie, there is force in this submission. First up, in as much as there are such orders in WP number, which is that
21,000 that order. Okay, the order I have given.
Right. So, next paragraph. In view of the above, operating the principle of verity, the same interim relief is accorded to the petitioner, as in WP number, so and so, so and so. Call this matter along with WP number in the third week of September. Next.
Second week of September, that is.
Along with the instead of date. So that it will come along.
Yes.
Okay. Yes.
Petitioner is claiming regulation of the service from initial engagement.
Similar matters we have already
Officials issued.
issue emergent notice. Call along with
OP number 1 and 2.
OP number 1 and 2.
And London Council, State Council accept 3 and 4.
Issue emergent notice to OP number 1 and 2. AGA for 3 and 4. But call this matter along with WP number.
Item 7.
My petition. And in this case, the petitioner is challenging the inaction in giving appointment.
Inaction in giving appointment.
My lord.
We should have been given the appointment order.
Yes, my lord. My lord, factual background in this case.
In WP, there was already direction. In 1542 of 2016.
Just I'm coming in brief, my lord.
No, I have read and I am asking you this question so that to save your time. I have abundant time. You do not have much time. Because you have to go to library and read, na?
My lord.
Yeah.
The petitioner was selectively selected in a selection process in 2016, my lord. Thereafter, the opposite party number 4 challenged such selection process, my lord. And thereafter, challenged before this honorable court and filed WPC number, my lord.
1512 of 2016.
Yes, my lord.
Yeah.
Wherein this honorable court directed the opposite party number 2 collector to consider the matter, my lord. And where the collector the matter, giving opportunity to both the OP number 4 and the petitioner and the collector confirm the appointment of the petitioner, my lord.
Void order dated 4th April 2020.
My lord.
That you have challenged.
No, my lord. Confirm my appointment.
Confirm your appointment.
My lord, that order was challenged in another writ petition by the other party.
By the OP number
And
4.
there is a interim order passed in that.
No, my lord.
But subject to result of the outcome of the.
Then we'll call this matter along with that.
Along with that.
My lord.
Issue notice. Learned DGA is requested to accept notice for OP numbers.
OP number
Up to 3, 1, 2, 3.
1, 2,
4
3.
notice.
Emergent notice to 4. Call this matter along with
WP number, my lord.
give that.
13649 of
Right
22.
down and give.
My lord. Well, may I pray, my lord? That matter already pleadings complete, my lord.
So we'll call, if that matter is posted, this also will be posted.
My lord, that was specifically adjourned to December 2024, but till date that has not been listed, my lord. I pray that may kindly be taken next week or any other day, my lord.
But date is fixed in that matter.
December 2024, my lord. Specifically adjourned, but
But here there is a private party.
Notice has to go, all this come. Let us see, after service you make some memo, then we will take that, because date is fixed in that matter. That is not here now.
my lord, that is 2024, that's why
Let us see. All along with WP number so and so. First one. It is open to the petitioner to move the matter if there is any urgency. Of
Item 8.
Item 8, the petitioner who retired as library technical assistant, Hon'Ble University, since 31/3/2000 till date, he has not been extended the retirement benefits, Your Lordship. Your Lordship,
But we should made an order, no, rejecting.
yes, Your Lordship.
Why they have rejected?
Your Lordship, may kindly see page 28 for a moment.
28.
My Lord, that is Annexure 7.
What they say?
That is the order at 31/7/2024, where my services were regularized from the date of initial appointment, that is 1990, as per the direction of this Honorable Court. The operative portion of direction is at page 27. Pursuant to page 27 direction, page 28 was issued. Yes, Your Lordship. Then I move.
They say excess payment was made.
No, Your Lordship. They are saying that is page 35 is the order of rejection.
That's what I'm seeing.
Yes, Your Lordship.
29. To,
Page 36.
please come to 29.
My Lord.
Clarify that. The excess payment, if any, as a result of fixation of pay in the revised pay structure. Long line.
Yes, Your Lordship.
2.5 lines.
That is the order in my favor, regularizing my service from the date of initial appointment.
Okay.
Then I approach this Honorable Court for the benefit of pension and other retirement benefits. That is page 33. After the order was passed, wherein my services were regularized from 1990.
Okay. That is rejected.
That's rejected. On the ground, Your Lordship, may kindly see page 36.
26.
Page 35 is the order, that is 29/4/2025, Annexure 10. Relevant page 36. Para 6.
Salary component of.
It is worthwhile mentioning here that the university is a state funding university and depends upon the state's government fund released through annual block grants to meet the salary component and other pensionary benefits of the regular teaching and non-teaching employees. The regularization of the service of petitioner university own fund as a salary and other emoluments are being met out. Here, Your Lordship, page 37.
They say they don't deny your claim.
No.
They say we don't have money. Take notice.
Yes, Lordship. And only one thing, page 37.
Anyway, notice
My
you
Lord.
have to take. Issue emergent notice. AGA for
OP number 1, OP number 2 and 3, university, private
for
analyst.
emergent notice to OP numbers 2 and 3. Returnable within 4 weeks. Yes.
1 and 4, my learned senior will accept 2 and 3 notice.
1 and 4. AGA 2 and 3. Okay.
Here, the claim of the petitioner for placement as professor as per the career advancement scheme of the UGC regulation.
Similar matters we have treated.
Not yet, Your Lordship.
Yeah, I remember.
Actually, the lead matter is 1203 of 25. If that matter is called along, these matters can be disposed of.
Issue emergent notice that the AGA to accept notice for response. All OPs.
Yes, Your Lordship.
All OPs.
No.
No private party.
No, only OP number 4 is private. The principal.
Emergent notice to OP now. call this matter. OP4 also he will take because principal.
Yes, government college.
This to be called along with which matter?
The other matter I'll mention, let the notice go in this matter.
No, 12,000 to the 12,000 kete kaile? I don't know.
Yes.
Item 10.
Here the petitioner is a professor of the Berhampur University. But considering there was a dispute between the present petitioner and one of the students of notes, which led to leveling of false allegation of sexual harassment against this present petitioner. And pursuant to it, notification under Annexure 2, page 18 was passed, whereby this petitioner was debarred from the examinership and all examination-related work. Page 18. Lordship sees, my lord, the very notification
For a period of 3 years.
for a period of 3 years.
In fact, 3 years will be over in November.
Has happened, my lord. In fact, while passing this notification, I was never afforded any opportunity of hearing. In fact, this notification indicates syndicate resolution number so and so dated 29/10/2022. On the basis of this syndicate resolution, it has been stated that this debarment was made for the petition.
But you have filed the petition when?
But this year.
Then why?
But the reason is that, Lord, a criminal proceeding was also initiated against the present petitioner, where he has been acquitted. After that, in the year 2023, after that,
Acquittal happened when?
My lord,
Acquittal happened when?
Lord, acquittal happened, my lord, on 5/6/2023, Annexure 4.
5/6/23.
My lord.
You filed the WP when?
Lord, WPC has been filed on 10/8/2020.
So why delay?
The reason being that, my lord, this petitioner has submitted repeated representations to recall this notification, because the resolution on the basis of which this notification has been passed.
Issue amendment. AGA is a party? No, only university.
Only university and state is a party. Higher education.
Why state is a party?
Because this university
University
is funded by
department of the state.
Yes.
51. Opposite party 1.
No, how university has an independent statutory
Yes,
body.
my lord.
What control they have? Like
No,
the
no,
funding.
I have only made party since I have made representations, and it is under the control of.
You delete OP number 1. OP number 1 not being a proper nor necessary party in the light of Rajia Begum is directed to be deleted from the array of parties. First, petitioner with the leave of court has amended the petition in the open court. Okay. Just put a signature and delete that. Issue emergent notice to OP number 2 and 3. The petitioner to redesignate OP number 2 as OP number 1. OP number 2 and 3 as OP numbers 1 and 2. Issue emergent notice. Returnable within 2-3 weeks.
In this case, no, the reason is that no, now the other students they are studying under the guidance of this petitioner. They are being debarred, and I am being debarred from acting as a guide to those students.
Let us see. No, that happened long ago, no?
Yes.
No,
Lordship may till then, Lordship may.
No.
But what I humbly pray.
It's a case of sexual harassment.
Lord, in fact, everything has been decided in my favor.
In the criminal case.
My lord. And in fact, this notification, Lordship sees, it has been passed on the basis of the syndicate resolution. The syndicate resolution, my lord, is silent regarding me. Nothing has been stated against me. In fact, there was no discussion.
Let us see. You come little early.
My lord, that
perhaps
in fact, I had submitted repeated representations, my lord, those are pending. That's
next. Lordship.
Item 11.
Yeah.
This similar matter was yesterday. This is the order your lordship passed. Taking into consideration the urgency involved, your lordship has fixed it to next week.
Issue emergent notice. Call along with the AGA appears for OPs. Call along with the signs.
Here in this case, the inquiry finding has been challenged. Only the inquiry finding, and the discipline.
We'll dispose of all those matters.
Yes, ma'am.
And then, of course, I understand what you are saying. You mean to say There is no
Order.
prio vigor order.
Yes.
So he can wait because inquiry findings may be reversed by the
Yes,
other.
after submission of inquiry finding, there are other steps also.
Other steps.
I have been noticed to file reply to the, but they are treating it as a third so-called notice.
Along with that, when those matters are posted?
Next week.
Next week.
Because no interim order has been passed therein, taking into consideration there is urgency involved, the lordship has been thought.
Item 12.
Next.
Here the petitioners are working as physical education instructor in different regularization.
Covered by judgment.
Yes, you also yesterday passed a similar order.
Yesterday, your lordship has issued notice.
No, it same matter. Yesterday,
Representation.
To consider the representation.
Yes. In the light of Jago, lordship already passed. And now, therefore, yesterday, another landmark judgment passed by the apex court. Lordship kindly refer to that.
You have printed the order now.
No, this is the corrected copy of lordship yesterday order. The lordship kindly this judgment. This is yesterday, day before yesterday. Apex court relying that Jago and Shripad passed another judgment, and your lordship, while sitting in division bench, also deliver a detailed judgment in the batch of cases.
Anyway, we will pass that order which you have given now.
And that order will also only add that two judgment, taking into concern that two judgment, recent judgment.
Supreme Court order to the Supreme Court.
Okay.
The representation date is corrected. I have already corrected.
The consideration to take place in the light of latest apex court decision in Dharam Singh and others versus State of UP and another civil appeal number 8558 of 2018 disposed of
$19
on 19/8/2025.
And your lordship judgment.
Apex court decision is there. You are very, very up to date. I have been seeing you. Yesterday, day before it has come, and now you are here.
The landmark regulation. They have stated that the state cannot claim take a ground that post is not created. You have to create the post.
Yes, that's what we held also.
Yes, that's
last month.
Yes.
Yeah, you have to create post and do it. Yes.
May I please? The petitioner, the legal heirs, my lord, praying for arrears salary from 2010 to 2024.
They are not given a salary?
No, madam. The DCJ employee already approved by the opposite party number 1 on 29/7/2009. Well, but till date, my lord, no financial benefit has been given.
You have given representation on 10/8/25.
No, madam.
Yes, it's there now.
Then earlier.
You are not given any representation.
No, madam.
But you should give representation. You take notice, brother.
Yes, madam.
Otherwise, I am not convinced that you will consider the representation in an honorable way. Simply you will reject that. I know the kind of officers we have here. Considered some clerk will write it and they will quote every story, and this officer will put his signature and say rejected. Issue emergent notice. ASC on request accepts notice for the OPs. Any private party?
Governing bodies.
I am for 1 and 2 men. 1 and 2.
Governing body is the private party.
Notice to others. Okay. Returnable within 4 weeks. Yes.
Item 14.
Item 14, may I please, Your Lordship?
Yeah.
Your Lordship, the petitioner is the demonstrator and the request of the petitioner for the grant of RACP benefit has been rejected, Your Lordship. Your Lordship was hearing a similar matter yesterday wherein notice was issued, Your Lordship.
Issue emergent notice. Your university is a party.
Principal is a party, Your Lordship.
OP, they are AGA takes notice.
Yes, Your Lordship.
ASC accept notice. Response. Call this matter along with WP number.
Except 5, my lord.
2254.
Except 5. Accountant General is the...
Accountant General has a sub-independent format. 45. Call along with WP number.
22549.
22549
of 2025.
Yes. Yes.
Your Lordship, it's a teacher transfer matter pursuant to NPM list notification is a similar matter of 20875 of 2025 covered matter.
It is covered by judgment.
Yes.
Which is that judgment?
WPC number 20875 of 2025.
Notice is issued in that matter
Yes.
or allowed? No, notice is issued. Okay. Issued. Who are the parties? Go to the cost title. In cost title, you should be able to say for who appears. At least private party, government party. You will start turning pages here. You do not come with preparation at all. Yes, go to the cost title.
All the opposition.
All the parties.
All the parties.
Accept notice for all the parties.
Yes, but really-
All this matter along with WP number. Give that.
But the petitioner has 20875 has been relieved by the on
Yeah, with the-
Covered.
let them. There is other matter also. Along with that, we will see that.
20875.
20875 875 of 2025.
2025.
25. Any entry order is granted.
Yes.
Yes, Your Lordship.
Entry order is granted. Entry order is granted. It's not governor's office.
Yes.
If they are relieved, you have to call them back. That's all. Learned counsel Timothy so argues that in identical matter, this court has already granted interim relief, and therefore similar relief should be accorded to her client as well. First off, there is some force in this submission. In WP number, so interim relief is granted. First off, next one, in the above circumstances, same order as has been granted in the cognate petition to be printed in this matter to call this matter along with WP number. So, next.
Item 16.
May I please understand?
Yeah.
Here the petitioner was appointed as a Shikshak in the year 2006, madam.
Charges to be questioned.
My lord, sake of the proceeding, why I have sought for, my lord, here the basis of the initiation of the proceeding is that I, being the member of general caste lady, married to a scheduled caste person, and while applying for the post of Shikshak, I got the appointment under the category of scheduled caste. That happened in the 2006.
By marriage, whether caste is changed.
No, that will not change. I am aware about your lordship's decision in Archana MG.
Yes.
But that case, that was relating to an election dispute. Your lordship
Makes no difference.
My lord.
My lord.
I am trying to convince your lordship. There, your lordship hold that no equitable relief can be granted. Here, take similar circumstance, one decision of division bench decision of the Honorable Supreme Court I have with me. In case of that Kendriya Vidyalaya Sangathan versus Shanti Araya Singhi, their lordship hold that this caste certificate should not have been granted. But since the person has got appointment and got this caste certificate without any fraudulent intention, therefore, she should not be removed from service, but however, she will not get any benefit for the scheduled caste in future for any other purpose. That is their lordship have taken the
Which year edition?
2010, madam.
Then law has moved. I think at that time, Melinda was holding the field. There, Melinda is diluted.
My lord.
Whether Melinda is referred to in that?
No, the whole decision has been referred to.
Huh?
Any Horo. 1971-72 Supreme Court. That Horo decision I have got. I have also just put highlight marker paragraph 24. Paragraph 24. In the portion, I'm reading, if non-Munda women's, page 783. Paragraph 24, middle portion, if a non-Munda woman, your lordship got it? if a non-Munda woman's marriage with a Munda male is valid, it is difficult to say that she will not become a member of Munda tribe. The concept of tribe is bound to undergo changes when numerous social, economic, educational.
Tribe is one thing, caste is another. Mahabharata says
that I have read that.
It is different. Caste is different. Caste is always 92 Supreme Court, Indra Sahani. That always in Mahabharata, in fact, there is one shloka which says, Daiva yatnam kule janma, Purusha yatnam Purusham. With the kula and caste, other things are decided by God.
Your Lordship quoted that.
Give that judgment. You are very fair in supporting me in dismissing your matter.
One thing I try to differentiate the circumstance that there your Lordship is considering the election petition, and that your Lordship also observed that election cases are covered by special statute where there is no question of equitable relief. So that cannot be granted. Here the lady has served for 19 years. And this certificate which she was being issued, that was not with fraudulent intention. And I have filed another aspect, vital aspect. I have challenged that cancellation order before the collector by way of filing an appeal. That I have annexed. And I also filed a representation before my authorities.
You face disciplinary inquiry.
My Lord, what I pray to?
I have to dismiss it now.
No, my Lord, I pray your Lordship to pay 39 kindly take.
No, what I have said. I have decided many matters.
Yes. I am well. That's why I made a submission that your Lordship's view I have to also read over.
It is an apex court's view.
My Lord. But
it's not my virgin view at all.
My Lord, one thing, my case is supported by a decision in case of the Delhi High Court. That is not yet been
on Milinda, though Milinda is not referred to.
Yes.
The undertone is of Milinda itself. In Milinda, where there is no fraud, etc., he should be permitted to continue the case.
Can your Lordship may say that yes, I have already participating in the proceeding because
the inquiry are at the earliest point of time. Otherwise, I may pass adverse order to you. Because there is no need for inquiry at all, because you admit that you do not belong to that caste.
No, because I'm a person of general caste.
Yeah, therefore, what need for inquiry? You should be simply sent home.
My Lord, here another aspect, another thing will happen. The cancellation order was passed by the Tahsildar himself, which he should not have been. Because in view of Madhu Patil decision,
where is the need for order? You admit that you are a member belonging to non-scheduled caste.
No. The question is required to be examined whether I got the certificate with my fraudulent intention or it has been granted by the authority.
No, whether it is fraud or not, certificate could not have been granted to you because admittedly you do not belong to that caste. Even if fraud action is taken away, still you are not entitled to that certificate at all. Because of Indra Sahani.
But here some matter is there.
Dismissed.
No, your Lordship may grant. I should face the disciplinary proceeding. I'm not. This decision with regard to terminate, they may terminate me.
They may terminate. Yes. Therefore, I am dismissing.
But
no, if there is any point, I would have allowed the petition. Do I hate this person? I don't know.
No.
I have to follow the law. You have made me a judge so that I will decide the cases in accordance with law. But in accordance with face value.
No, absolutely not. But in case of the Delhi High Court decision, since that is in my favor.
A delinquent employee is knocking at the doors of writ court with the following prayer. First off. Next paragraph. OP learned ASC appearing for the OPs opposes the petition, contending that admittedly petitioner does not belong to scheduled caste and that the law has long been settled in this country that caste is by birth. Why the Indra Sahani versus Union of India 92 Supreme Court. Right? Just looking. And therefore, there is absolutely no reason to grant the indulgence in the matter. First, I agree with this view. First, next time, in any circumstance, the inquiry proceeding is going on, which involves alleged fraud in obtaining a social status certificate, and petitioner already filed her explanation to the show cause notice, and therefore she should participate in the subject inquiry, which shall be culminated into some order with full participation of all the stakeholders. First, next paragraph, with the above observations, petition is disposed of. First, the subject inquiry to be completed within a period of 6 months. All contentions are kept over. Next.
Item 17.
Thanks for making research and telling me that these are the judgments. Those judgments just keep on making. Okay. Yes.
Item 17.
No, please. Wait, 2009 matter. Huh? Knew that. You appear for petitioner.
Transport.
Brief has been transferred. To whom it is transferred?
Mr. Roy, Dilip Roy.
Dilip Roy. Learned counsel appearing for the petitioner submits that the brief has been transferred to another counsel, namely Shri Dilip Roy. First, post this matter. We copy next. Printing name of Mr. Dilip Roy as representing the petition.
Already reflected. His name is reflected.
Reflected. Yes. Okay. You want to retire from the case?
Yes, ma'am.
Permitted. Then only this. He is not here. Dilip Roy is there.
Yes, ma'am. Name is there.
No, his name is there. But he is not here.
Yes.
So, this is a very old, recall that one. Very old matter of 2009. First of reluctantly adjourned by 2 weeks to afford an opportunity to the counsel appearing for the petitioner to come and argue, failing which petition is likely to be dismissed. Next date of him, call immediately after 2 weeks.
Item 19.
Yes, 19. 2018 matter, recalling the order date of 2019.
May I please?
Yes.
Highly IA for recalling the order dated 16th.
What was that order?
Order, my lord, expect the order against a similar order. My lord, condone the delay and recalling the order.
You have already done that because of coordinate bench decision.
Your lordship judgment.
I have followed coordinate bench decision.
Your lordship order.
Months.
Yes, my.
दिन डिले हो जाएगा ना डिले कितने दिन है 18
Mr. G.
Well,
Identical matters we have already.
Yes.
The subject matter. The subject matter of this application is substantially similar to the one in TMA PL number 216 of 2020. Wherein similar application in IA number 95 of 2020 having been favored, the dismissal order has been recalled. Argues counsel for the applicant. First law. He has also placed on record a copy of this court's order in Krishna Mishra versus State of Odisha. CMAPL number 216 of 2020 to vouch his submission. First submission is vouched. First, next part. In the above circumstances, delay is condoned. Application is allowed and delay is condoned. First term, the request for restoration of CMP by recalling order dated
16/10/2009
is accorded. As a consequence, main matter is restored to the board for consideration of fresh. If you want any clarification,
deglobalization.
Item 20.
Item number 20. Well, there are three matters in item number 20. My lord, the two second matters, my lord, they are different and first matter. So first of all,
they are not similar matters.
They are not similar matters because they are. Let me clarify. The first matter, as per my instruction, relates to recruitment of Sanskrit teachers. Whereas the second two matters relate to relate to Hindi teachers, recruitment of Hindi teachers. So the second two matters are identical. So let the first matter be segregated from the second matters and separate. This is just a minute. This is my first submission. Second submission, my lord, you lords may correct. Our matters have been specifically fixed by your lordships as per the cause, as it reveals from the cause list to the second week of September. Now, my lord, this has appeared today in your lordship's board, and my lord, we are not informed who has mentioned it for getting our matter list.
In this case, counter and your lordship, in this case, counter and rejoinder has already been filed. Your lordship humbly prays that the matter may be posted to second week of September. The final, your lordship may decide the matter.
That matter.
Yes.
Two second matters. Last two matters. So far as last two matters are concerned, that is relating to the post of Hindi teacher. I have also filed application for intervention in both the matters. My intervention application has not yet come. Your lordship may call for my intervention application and allow the intervention application.
Highly objects.
And
by the way, there is no objection for his
petition. Entire
permission, may I say?
How you are agreeing that matter is detagged?
No matter. I am for the staff selection commission. Here,
no, he is saying mine is Hindi, mine is Sanskrit post, teacher's post. They are Hindi teacher's post. In that, Mr. Swain has already moved application for interview.
That is not there in the list.
I have already filed, but it has not come.
But the issue is
it is not posted.
Right.
The issue is same. Issue is same.
But
issue is same.
Is mine.
Kindly.
The issue is same.
Read about it. Your matter, he will argue his matter.
The difficulty is that because of the interim order passed by this honorable court staying the entire selection process, we are being affected. So your lordship may hear this matter finally at an early date. That is my second request.
WPC, which is that to be detached.
Last matter is to be detached from the second two matters.
WPC 16242 of 2025 to be detached from
number to the
detached from other matters, and it is to be posted along with WP number.
That is the single matter. That is the single matter.
The application, intervention application.
Well, I have given the number.
Number so.
Well, that is IA number 14265 of 2025 in the first matter.
142.
The copy may be short.
No, one second.
14265 of 2025 in the first matter. That is Firoz Kumar Mahapatra's matter. And second matter. Second matter is have given the number. I have filed in Rakesh Kumar Barik case. I have also filed intervention applications. In my sleep, I have given the numbers.
Yes, on this matter in second week of September. Then the other matters to be
interim order to continue.
Interim order to continue till next week. In WP is that next week. All these matters of the WP 16242 of 2025 is posted. Same day it will.
Yes.
So that these matters will appear on the same day.
Yes.
But separately.
But separately.
Yes.
Post intervention application in IA number.
That I have given. In the second matter, I have given in a sleep.
Along with you. Second.
Allowed in the first.
Your Lordship allowed that IA.
Not allowing it is to be put.
The first sub-item, WPC number 16242 of 2025. I have filed an IA, my lord, that is one.
All IAs to be posted along with you.
Lord, that is for intervention, my lord.
That's what. It has to come before the court. It is not posted to.
No, that is it is already.
Let us see. There is one more application, na?
Then a copy may be directed to be short.
New copy. Wherever is that to continue till next day. Item 21.
Again. My lords, small claimants. In item 20, my lords, two more IAs for intervention are issued to me. 14262 of 2025 IA number.
All pending applications I have said they should be.
Giving the phone number, man. Those.
Yes. Item 21.
21. I filed an application for amendment of one date, my lord. Page 5 of the writ petition.
Petitioner has moved an application seeking rectification of the date at paragraph page
5, my lord.
Page 5 of the petition.
Third line, my lord.
First one. Application is supported by an affidavit and the mistake appears to be due to
the mistake in the document itself.
By supplementing the documents, correct document.
But he wants to amend this. He can say if it is not correct because document says some other date.
No, he has filed one document and the date incorporated in that document
matches with the present one.
Not matches.
Matches with the present one.
Yes.
But now he wants to amend this his petition.
So the document has to be
that question arises.
My lord,
when you argue the matter.
No, my lord, I will directed maybe substitute the document. The document in Xerox, when it is Xerox, the year 22 has been omitted. So I filed also the document.
What is your prayer?
So to accept that of my corrected document, also.
Main matter, what is that main matter about?
My main matter for promotion, my lord. National promotion, again. A document basis.
That Allah will take.
I am giving the, I may be permitted something.
I will be permitted to say something.
Again.
I will take up your application along with the main matter. That's all.
Unless until that document substituted, it will be incorrect because in his petition in document one date. So I want to substitute that document also. I paid many amendments.
And the present document is accepted. The nature and character of the case may be changed. Yes. The document.
That is bold. That's why amendment regala na.
The best way I will suggest to you, you withdraw this petition. I will give liberty to file the fresh one with consultation.
Yes, that is the best.
Which year matter it is?
25.
25 only. I will permit you. What is the difficulty? All right. Learned counsel for the petitioner has moved an application seeking amendment of the petition. And he wants to produce some other document in support of the intended rectification of the date. First, learned AGA opposes the application, saying that if that is allowed, that would change the very nature of the proceedings. First off, next paragraph. At this stage, learned counsel for the petitioner seeks leave of the court to withdraw this petition with liberty to file a fresh petition with all rectifications as he desires. First off, prayer is innocuous and therefore cannot be rejected. First off, in the above circumstances, petition is disposed of as having been withdrawn with liberty as on.
Of highly praised petition.
Yes. Next.
Item 22.
May I progress?
Yes.
In this case, my appellants have challenged the order dated 11/10/2023 passed by the Learned State Education Tribunal under Annex 16 page 82
Yeah.
Rejecting the interim payout of the appellants to the release of current salary in their favor on the ground that unless the matter is finally adjudicated
He is working.
The appellants are continuing uninterrupted.
Continuing.
My lord.
Even after working, they are not giving the salary.
Current salaries.
And the tribunal says you need not be paid.
My lord.
You should have asked the judge to give his salary for your survival. What matter about when he is working? Well, how can you withhold the salary?
There is a delay of this.
Right.
Yes.
He is working. Do you deny that he is working? You mean to say that he should work with starvation? Ultimately, what should happen to the main matter is another thing. As long as he continues in service, he has to be paid the salary.
Till November 21,
Management will pay him. Management will pay him, not the government.
Management has to pay that. Then notice has to
Delay.
My lord, I will assist him. My lord, here the appointment of the petitioners, appointments of the petitioners have been approved.
System?
Yes, yes.
Direct payment
Their appointments have been approved. They were getting their salary, but all in a sudden that has been stopped.
That way. It's not management. If it is direct payment, which you argued,
yes, direct payment system.
It is if it is DPS.
Yes.
Then government itself.
Annexure 9. Annexure 9 is the approval order.
In one matter.
Annexure 9 is the approval order.
Annexure 9 is the approval order. So use the word direct payment.
Yes. They are receiving block grant.
Just look into that and come back. We'll call this matter on Tuesday. How it should survive?
My lord, let's call this matter on Tuesday.
Permission it has come.
Yes, ma'am.
Yes. On mention it has come.
Issue emergent notice. Learned AG is requested to accept notice for OP numbers.
OP numbers, my lord. 1, 2, my lord.
1, 2. 1 and 2.
1 and 2 and 4.
1, 2 and 4.
PSC notice be issued.
Three. We'll say returnable within 1 week.
Yes.
Returnable within 1 week. Yes.
Along with delay notice.
Along with?
Delay.
Along with application.
Limited
donation of delay. Okay.
Item 23.
You'll have to call it and do accept it.
Next week I am calling this.
Next
2 weeks.
Next week only two.
Week after next.
Only 2 days.
That's true. Week after next we'll do this. Okay. Yes.
Ma'am, his case I am for the caveat. But in the solve the
it may not be required. This is an appeal challenging the interim order passed by the Learned Education Tribunal by refusing to grant interim stay. Now, my submission.
Main matter itself.
Yes, that is my submission.
Then I am agree.
In the meantime, the main matter is also otherwise ready for hearing.
Petition has the following prayer. First, learned counsel for the petitioner very fairly if the main matter itself is directed to be disposed of by the tribunal.
In GIA case number 18 of
GIA case number
18 of 2023.
18 of 2023. Arising out of GIA case number 21 of 2023. Correct?
Yes, this case number 18 of 2023.
Arising out of your seat.
No. I'm excuse my
by mistake. GIA. Then first in
Miss case number 18.
Miss case number 18 of 2023. Arising out of GIA case number
21 of 2023.
21 of
2023.
2023. itself is disposed of. What is it? Science. First time. With this proposal, even learned counsel appearing for the caveator is agreeable. Rightly. First. Next paragraph. In the above circumstances, one sentence here. Learned counsel for the petitioner also reminds the court that the right to speedy justice is part of Article 21 of the Constitution of India, as held by the apex court in a category of decisions. In the above circumstances, petition is disposed of. Requesting, appeal is disposed of. Requesting which tribunal it is?
State Education Tribunal.
State Education Tribunal at Bhubaneswar. To hear and dispose of miscellaneous case.
GI case.
GIA number 221 of 2023 within an outer limit of 6 months. 6 months. First, all contentions of the party are kept.
And the present appeal, there is a delay of 49 days. You also may condone the delay.
May not be. I am just saying that
yes,
this one application fails into insignificance. Item 25.
Yeah, in this case, I am challenging the order passed by the Lana State Education Tribunal.
Yeah.
Similar issues. This Hon'Ble Court has passed this order.
Covered by judgment.
Yes, ma'am. Yes, because.
Show it to you. I am giving to your friend also.
My lord, I am giving.
Otherwise, they will be in darkness.
Yes. The Hon'Ble Court has been pleased to direct the opposite parties to re-verify the issues of the claimants within a period of 6 months.
25.
You want? Do you want to look into according to this?
No, your Lordship, private parties is there here. They have to be
notice has to.
Then second,
the issue
there is a delay of 1,095 days.
There's some delay. And this in the coordinate
1,095.
Yes.
The coordinate bench of the Hon'Ble Court has passed this order by considering the delay. It's because in similar cases, the Hon'Ble Court has been pleased to direct the government and the higher education department to look into the grievance of the petitioners. Those who have submitted the proposal before repealment of the 1994 J order. That is the issue. Only if this case
you have come to court very belatedly.
Yes, I have. That is admitted.
What is your explanation?
My explanation is the order was passed on. You know, the petition I have mentioned, my lord. The original order was passed by the Learned Tribunal on dated. That is 9/12/2019.
9/12/19. 2019, even before COVID.
Just before 2 months of COVID.
So that you cannot say because you could not foresee COVID was coming.
No, it's because at this stage I had to file the appeal within 2 months, my lord. And when I prepared myself to file the FAO, my lord, the COVID started, my lord. The COVID started 2020, my lord.
That was in 9/12/2019. March. What we were that? Is it the reason you have shown that?
My lord, yeah, I mentioned.
Where is that?
Paragraph 3 of my limitation petition.
9/12. But the limitation expired before the onset of COVID.
Just 15 days, my lord.
Correct.
Just before 15 days.
Then
by that time, my lord, even if there was shutdown from March, my lord, but by that time the COVID situation was already started. So, my lord, when moving here and there was
when it came to an end.
Here, 2021 last
22 March.
28 February.
28 February 22.
Present petition filed in 25.
You wanted another COVID to come?
No. Similar, excluding that period, you must kindly consider because
how? Okay. Delay is very, very long.
There is a
you take notice. Let us say yes. Learned AG issue emergent notice. Learned AG has requested to accept notice for OP numbers?
OP 1 and 2.
1 and 2. Emergent notice to OP number 3. Both on IA and main matter. But in all cases, it should go together. There is one judgment of the apex court. You cannot split it. I do not know why that is not followed in this court. Yes.
Item 26.
Item 26, Annexure 9 representation is pending regarding notification and a grant of granted in favor of the petitioner schools.
No, that's no problem. Yeah, representation though. What representation will do?
This school for granted board. Earlier, this Hon'Ble Court, the school to notification for notification of the school, so given a representation to the.
Well, what's your right to get the aid?
Yes, madam.
Where is the right to get the aid? Granting aid says that it is not, it's a matter of compassion like that. There is one provision which I read. What is your right to get the aid? You establish that right, then we will direct them to consider the. Otherwise, they will say, because there is a court order, we will grant the aid. No, that cannot be like that. You prima facie show what is your right.
Sir, the next week, sir.
You will show it next week.
Next week.
Okay, because 2 weeks at the request of. Next.
Item 27.
Petition, sorry, the appellant has challenged the appellate provision in the FO, but in the meantime, the bench has passed a similar order. The Lordship kindly glance.
Which your friend has shown.
Yes, yes.
What is the delay?
Delay is more than 1,000.
More than 1,000. Then whatever will happen to that case will happen to your case also. So we'll call this matter along with that matter.
But I am saying that in the similar circumstances, the state has also been able to pray before this Hon'Ble Court for condonation of the delays and more than 1,000, right? And that has been also.
That has been condoned.
My lord, this.
You take notice. There are private parties also.
Yes, private parties will
issue emergent notice.
Yes,
emergent notice. EGA to accept notice for
1 and 2.
1 and 2, emergent notice to the rest.
Department 2, I will take one by register post to 3.
Yes, whichever normative way. Yes.
Item 28. May please, Lord.
Yes.
On behalf of Madam Jena, I may be permitted to submit.
You want to submit?
Submit.
Yes,
in this matter, we have no instruction. 1 week time may kindly be granted to take instruction in this matter.
Which year matter?
2013.
Then how many years have lapsed now? 2 weeks.
Perhaps in the meantime, the matter become infructuous.
It has become infructuous.
Perhaps 1 week time may kindly be granted. We will take instruction.
No, you know that it has become infructuous.
Madam Jena told me that perhaps the matter become infructuous. 1 week time may kindly be granted.
All right. Call next week at the matter urgent reluctantly since very old. Okay.
Item 29.
May I please, madam. Madam, in this case, madam, permitted to no instruction and liberty to file better application if any cause of action survive, madam, because we have no instruction regarding this matter, madam. And try to contact the client board.
What should be done in the matter?
Dispose of like no instruction and liberty granted to if any cause of action survive in future.
You want to withdraw the petition?
Withdraw, madam.
Do you want to withdraw the WP?
No, madam. Matter can be disposed of as no instruction, madam.
On that.
Same thing. Lordship.
We have kept it pending for all these years, and the litigant will say what kind of judge he is. He has kept a matter pending for so many years and now denying relief to me on the ground that it is.
But can we taken up next week? We will take instruction whether he is interested or not.
Next week, finally. Yes. The request. Yes.
Item 30.
Merely because matter is pending very long, I can't deny relief to the litigant.
No.
In fact,
No.
I will be committing a sin He will ask why you kept that matter pending for all these years. And now, because of your fault, you want to dismiss the petition. What I should answer? 30? 30. What is this matter about?
No, it's not a matter of state, my lord. It's Chief Executive Capital Cooperative Housing Limited.
Kind of prayers, I do not. I have to undergo training at the hands of you people to understand the prayers. None appears for the petitioner in this very old matter, within this decade-old matter. We must not call this matter next week, for a week after next, for possible dismissal. Registry to show into brackets for dismissal in the call list. Yes. Item 31.
May I please, Lords?
None appears for the.
May I please?
Yes, 31.
But here,
yes,
the GA department, Government of Odisha, my lord, they published a, my lord, they came up with a scheme for allotment of lands within the, my lord, Bhubaneswar town area. My prayer is, my lord, my allotment has been illegally cancelled without giving me notice, without giving me so-called notice, because, my lord, I could not deposit. My lord, the land was allotted to me, my lord. It is in the year 2003, around the year 2003, my lord. Agreement was executed. If your lordship will kindly...
Agreement is dated.
Dated, this was... It was in the year 1992, my lord. And agreement is...
Your calendar does not have dates at all, only year.
The lease made on this, the second day of July 1992, my lord.
It was lease agreement.
Lease agreement, my lord.
Lease dated
22/7/1992.
92?
Yes.
But you said allotment is of 2003.
No, my lord.
You only said that.
Yes,
it is available online.
My lord, there is an instruction your lordship directed me to
take
that.
Correct.
The GA department instruction saying that the suit plot bearing number so and so measuring 40 feet by 60 feet in Mauja Bharatpur was allotted in favor of this petitioner. Subsequently, on 25/7/2011, he applied for conversion of the leasehold plot to a freehold.
For conversion to freehold.
Freehold. It was a leasehold plot.
Annexure 5.
My lord. Thereafter, my lord, accordingly, the conversion was allowed on 29/9/11. And, my lord.
29/11/2000.
29/9/2011.
How can that be? He had applied only on 25/7/2012.
Yes.
How it can be allowed before his application?
2007-2011 I have.
2011.
11 I have.
2007-2011.
Lordship में कर लिया.
खाली कोई दो जटिके हमने सब कल तक बता दो.
No wrong date then.
My lord, he has applied for conversion on 25/7/2011. And conversion
number it is allowed.
My lord. And communicated to the petitioner in his address as given in the conversion application by letter number so and so on 12/12/2011. It was communicated to him.
Communicated on 12/12.
Yes. With instruction to deposit rupees 4,44077 rupees on the side of bank draft.
to make certain payment.
Yes. My lord.
Did he not make?
My lord, he didn't make. The conversion plot number so and so into freehold, the registration RPL was received back by in the department on 27/12/2011. Being undelivered to the postal remarks, gone outside village, always absent, returned to the sender. That letter which were sent, it was
not reach him.
Didn't reach him, my lord. Due to default in payment of premium, the permission of conversion was rejected and intimated to the lessee in the same address by letter number so and so, my lord.
Yeah. Here, my lord, if your lordship will, my lord, my lord friend has already submitted, my lord, on 12/12/2011, they issued me a, my lord, letter asking me to, my lord. That letter was never served on me, my lord. So I was not, no, it was not, never served. That he admitted, that it has returned back.
Return means you were not there.
I was not there, my lord.
You should have intimated before leaving that spot.
No, for a particular time, my lord.
You should have intimated.
Yes, ma'am.
During these days, I shall not be available. Therefore, you take note of that. Did you inform the authority?
No, my lord. I have not informed, my lord. But for only 5-7 days, I had gone out of station, my lord. During that period, it came to me and it was returned, my lord, not served on me, and it was returned back to the G department, my lord. Thereafter, my lord, I was bona fidely waiting for the receipt of the because, my lord, I have already invested so much amount for allotment of the land to me, my lord. I have already deposited, my lord. And this 44,000 I could have deposited had there been proper intuition to me, my lord.
Before when you should have paid that?
My lord,
he has not paid.
You should have paid that 44,000.
That they
on 12/12/2011.
Yes, when they had asked me to deposit within 30 days, my lord.
Yes.
But because it was never served with me, I was
now
not.
You pay with the bank interest.
Yes, my lord. I am ready to pay it, my lord.
Well, during that period, it was 12% per annum. Let him pay 12%. Whatever amount is payable, you accept that and you regularize it.
Yes, my lord.
You file a memo that you are agreeable to pay in.
Lordship can record my submission, my lord.
Where is the
Yes, my lord, I will file
a memo.
I will give you a memo.
Do that at least. Good. Petitioner has scripted
valuable lands, my lord.
The prayer.
Valuable lands.
But you have already given this. Scripted the prayer as and first. The essential grievance of the petitioner is against the cancellation of order dated 29/9/2011, whereby the plot in question was converted to a freehold. The lease agreement itself being dated 22/7/1992. Next paragraph. Learned counsel for the petitioner argues that before cancelling the freehold conversion, he has not been heard in the matter, and that the letter dated 12/12/2011, by virtue of which he was asked to remit a particular sum of money, had not been served on him, and therefore the impugned action is liable to be voided. First, next one. Kindly be seated. Yes. Learned the AGA appearing for the OPs, all OPs?
Yes.
OPs, vehemently opposes the petition, contending that petitioner had applied for conversion to freehold, the application dated 25/7/2011, and the same having been processed was allowed, wide order dated 29/9/2011, and thereafter a communication dated 12/12/2011 was sent to the petitioner which returned unserved on the ground that addressee was not available. First of all, that being the position, it was the duty of the petitioner to have interaction with the concerned officials to know the fate of his application, and this having not been done, he cannot be permitted to allege violation of principles of natural justice. First, he also brings to the notice of court the present market price of the subject property being too high. First, next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter as under and for the following reasons. 1. The plot in question was allotted to the petitioner, and pursuant to allotment letter, a lease came to be executed on 22/7/1992 are not in dispute. First, petitioner had applied for conversion of the leasehold into a freehold, wide application dated 25/7/2011, and that the said application came to be favored by the jurisdictional OP. Wide order dated 29/9/2011 are also not in dispute. First of all, thus some concrete interest was blown up to the full extent in favor of the petitioner by virtue of the order dated 29/9/2011. First of all, such a blown up interest cannot be blown just like piercing the balloon. Interest being the property in terms of Article 300 capital A of the Constitution of India, as expansively construed by the Apex Court in KT Plantations. First, next paragraph. 2, it is that a communication dated 12/12/2011 was sent to the petitioner, asking him to remit a particular sum of money by way of charges for conversion to freehold. First off. However, the said letter, admittedly returned unserved on the petitioner, maybe because he was away from the station for a short while. First off, why no reminder was sent to the petitioner calling upon him to make the payment is also not forthcoming. First off, in matters like this, it is ideal to expect 1 or 2 reminders. First off. Next paragraph. Learned counsel for the petitioner, in all fairness, submits, and he has filed a memo to the effect that his client shall be paying 12% interest per annum on the amount he was required to remit to the jurisdictional OP pursuant to communication dated 12/12/2011 with retrospective effect. First off, in other words, the memo reads as under.
I have given it. Can I pray, my lord?
Yes.
Present cost, whatever the present cost. Present cost, yes, whatever cost at present, prevailing cost Get him paid.
No, prevailing cost means, my lord, I have deposited the amount when the allotment
application.
When the allotment was.
But that was for lease.
That was for allotment. My lord, that lease subsequently it made. So I have already deposited that amount, my lord. Only the conversion charges I was required.
Conversion charges.
Correct.
And whatever is
that conversion charges with interest deposit, my lord.
No, it's not that simple. It's only interest is not the question, because the rate of interest does not match with the rising prices of the commodities, the real estate. Therefore, something more to be paid.
No, your lordship is saying, my lord, interest to be paid on the date when this conversion was allowed, my lord. At the rate of that interest percentage, reasoning at that point of
compound interest you have to pay.
Compound interest will be too difficult.
Let him pay compound interest.
My lord,
compound interest with yearly rest. With yearly rest. Yes. That would balance the equity. You have to say compound interest in your memo. Otherwise, I am dismissing the bill. Because there is some point which is now pointing out, which strikes at the mind of the court.
I'll write it, my lord, in my.
You write that. So that the matter, the order has to be sustained in appeal. You have to ensure that you succeed here. I have to ensure my order is not interfered.
But this, my lord, I have filed this application since 2015, my lord. 2015, I have filed this application, my lord.
That's all.
Kept pending here, my lord.
You could have you said that I am remitting the money in your application?
Yes, no, that.
Where have you stated?
To deposit that amount, sir. That I have not, sir.
Then you want to retain the money in your pocket and make use of your business?
Not that.
And thereafter, one fine day, you want to make the payment. Therefore, make it a compromise.
What my friend says, my lord, there is now a consent fee is also imposed.
That
consent fee.
By your lordship.
Consent fee, the division bench question.
Yes. No, your
I followed. Only followed the division.
Your lordship passed that order 2-3 days back.
Lordship, may record my submission and
one more sentence. DG also tells that now there is a requirement of payment of conversion consent charges. Consent charges. Okay. Then
interest.
Thereafter, next point. The submission of learned AGA that in addition to the conversion charges, there is a liability on the part of the allottee of the site to pay the consent charges is a bit difficult to maintenance in as much as such a requirement has been liquidated by the division bench of this court in so and so. Can you give that judgment? I have.
Also, I'll give.
Yes. I'll give that. We wrote that now. Just mention that. In the above circumstances,
Your lordship has so that judgment in Ashok Mishra's case. 5 or 6 days back, your lordship.
That's last week.
Compound interest. Compound interest.
DB, anybody can get the DB judgment of Honorable Chief Justice and
yes, I will prove
in the above circumstances, this petition conditionally succeeds. Semicolon. The writ of temporary issues flashing the order dated 27. What is that order?
Annexure 7,
24/11/2014. A copy whereof avails at Annexure 7. First, a writ of mandamus issues to the respondents to restore the freehold status of the subject lot, as was done pursuant to order dated 29/9/2011, subject to the condition that shall pay compound interest at the rate of 12% per annum with annual rest within a period of 6 weeks.
Till date, my lord. From that date till date.
First, it is next paragraph. It is made clear that the interest, as mentioned above, shall accrue due with effect from
24/11. 24/11/2014.
No, communication is 12/12/2011. 12/12/2011. Yes. If interest is not paid, the petition shall be treated as having, this order shall be treated as having been withdrawn on its own. Yes.
May I play one thing, my lord?
Yes.
Your lordship may direct the state to calculate the amount on the basis of the order, whatever your lordship has
Again,
passed.
for them, you calculate and make it payment. It's a calculation. You can also do.
I can do, but
You remit that
if
calculation.
they do, it will be convenient for me because they will say,
It will be inconvenient to them. You are the debtor under this order. It is the duty of the debtor to change a passage, the creditor who runs into the ship. The English judgment that creditor was traveling abroad in Leparis ship. The English court said it was your duty to make efforts to gain entry to the ship and put the money into the pocket of the creditor. That is the law. Yes.
the lordship
You
has
should make
granted
it within 6 weeks. It's a
8
matter of
weeks.
calculation.
8 weeks, your lordship.
Huh?
8 weeks, your lordship.
8 weeks. 8 weeks. But even that 8 weeks also will carry interest. That 8 weeks also will carry.
Yes, my lord. Till I deposit, I have already mentioned that.
Till actual payment is made. Okay. 332?
It's still true. One side, place the date that I had given.
Which one, sir?
This 32 item.
32.
Yeah, that will be convenient. If that is there, will not.
What is this matter about? I don't remember.
No, not before your lordship. Earlier, that was before my lord Justice R.K. Patnaik. I had given a
date chart.
I had given my lord. I think
it is here. Date of events. Yeah.
If
It
that
is
is
here.
It is here.
Cut.
Right.
Yes.
My lord,
Can I, with your kind permission, can I leave for 3 minutes and come back?
Yes.
Yes.
Thank you.
Just within 3 minutes. Sir. Kindly be seated. You need not stand up. Yes. Yes.
Lordship, kindly see my prayer. We have prayed that the Hon'Ble Court will justice suppress cases from to so forth as to high they shall not be commanded to finally allot the plot by completing all formalities pursuant to the allotment under Annex 36 and also deliver possession to the petitioner and or in exchange of the said allotted plot with any other.
The prayer is for direction to allot you possession.
Yes.
That's your prayer. That's what I gather impression by reading your
Right.
verbose prayer.
And taking into consideration Annexes 7, 9 and 10. That I'll also show to your lordships.
Yeah.
But here lordship kindly come to the debt chart.
Whether that plot is available as on today.
Plot is available.
With the due humility, my lords, petitioner earlier was selected for allotment of plot number.
No, I am asking a question.
But that plot,
the plot is still available or not?
The plot is still available. But Hon'Ble High Court directed to put it in auction and petitioner come before the Hon'Ble High Court. Hon'Ble High Court in division.
Let him complete the argument. Then we'll hear you. Yes, sir.
Well, the BDA published an advertisement in Orissa, Delhi for allotting in the district center at Chandrasekharpur Commercial Complex a built-up shop room.
Advertisement dated?
Advertisement date is Annexure 1, that is dated 16/1, sorry, the last date was 16/1. 16/1/93 was the last date.
No, I'm asking the date of the advertisement.
Date of advertisement.
In your date chart also it is not mentioned.
That is not mentioned because Annexure 1 does not indicate the date.
Because you have selectively produced it. If you had produced it fully, it would have indicated. Anyway, which date, sir, last date for this one is?
Last date was 16/1/93.
So we'll say January. Well, can it be January?
Yes, right. That means that.
93.
93. Sorry. 93. 93.
All. Then you applied.
Then petition applied under Annexure 2 applied. Then on 60, that is a...
Applied on?
Applied Annexure 2 date.
Annexure?
Annexure 2. Applied.
Date?
That is... anything that did.
Can I pass over so that you will prepare and come back? Because I will such questions, many such questions are.
Let's keep it to some other date.
All right. Call this matter week after next at the request of the senior advocate appearing for the petitioner. Therefore, I always request, especially youngsters, I request, prepare a date. It should be only palm size. Should not be more than palm size. If you see this palm, everything should be reflected.
That is right. That is right.
That does not require much work at all. It becomes easy for you.
Only pertinent dates should be.
Pertinent dates.
Only pertinent dates.
Yeah. Otherwise, what happens? You will go on turning the pages. The judge loses the patience. Others who are sitting behind also will lose patience.
That is right. That is right.
Is also
that is right.
Anyway, yes, next week we will have that. Yes, call
next week.
Week after next.
2 days.
Week after next.
Yes.
Week after. At the request of learned senior advocate Sri. Science.
Item 33?
Yes. Yes.
I was, I had participated. The petitioner is a retired judicial officer. He applied for a plot and in lottery lot. After 2 times change, they were changed.
Can we have the foundational facts?
Yes, Lord. That's what I applied for a plot under the BDA.
Pursuant to which advertisement? Lord. Which policy?
I have, may not be necessary, but I have prepared a date chart. Date chart. I had deposited it.
They have submitted the date chart.
I give another one.
Do we have date chart here? No date chart. Do you have one more copy? Please. You give your copy so that I will return you when you start.
So not necessary valid because it's a covered.
Covered may not be necessary, but
necessary.
May not be necessary.
Decision judgment matter is covered by the judgment.
And that already government decided, BDA also on principle decided that single discretionary allotment, if you have availed it, then this should be released from the task force report. They would be lease deed would be executed. All these things will be done subject to compliance of some of the criteria, filing affidavit and all these things.
Then we'll debate
this notification.
That is why I say that
I talked with my
lordship.
We did that judgment.
Not judgment. Not judgment. I will just your lordship may permit me 2-3 minutes. Page 31, your lordship may say.
Page 30.
Lord, as I was telling, I had applied after 2 times changes. Ultimately, matter came up to this problem.
17/8/2009.
17/8/2009. Your lordship, that will make it.
In view of the above, we are of the opinion that the problem can be resolved If plot number so and so is allotted in favor of the petitioner,
Myself.
and so
In favor of Shamsundar Tekli.
when the allottee of plot number so
Shamsundar is agreed to leave that plot and take the plot.
plot bearing number. So what was allotted is that there is no reason as to why the BDA shall not take steps in the taking.
Let the handing over possession.
Yes, there is already an order in your favor.
Already.
This is annexure.
No, that is annexure 6.
Annexure 6. WP number?
WP number 11423 of 2005. Dated 17/8/2009.
Annexure
6. Annexure 6.
Yeah.
Right, sir. So therefore, we need not go to the other because ultimately this. And in pursuance of this order, I took over possession. I got the BDA approval and constructed my building, and I am staying. At this stage of execution of the document, transfer document, instrument, they gave this annexure 1, at page 15.
But why you are using the word instrument? Any significance?
Yes, lease deed was to be executed.
That's a document.
No.
Instrument is the concept that obtains in the stamp duty law.
Yes.
Document is the concept.
Yes, I correct. I stand correct. Whereas a plot very so and so, that plot which your lordship saw in that order, quoted in that order, was allotted in your favor under discretionary quota. Right, sir. And whereas all such allotments were scrutinized by the task force appointed for the purpose of trial, recommended state government to cancel such agreement, and whereas state government has accepted the recommendation and accordingly.
Why it should not be cancelled?
At this stage, I came to your lordship, and there was an interim order that the proceeding will continue, but no final order of cancellation will be passed. At this stage, when the first your lordship sees the first line, allotted in your favor under discretionary quota. This is an error because your lordship sees
it is pursuant to order of the court.
Now, the decision which my lord friend is saying, just passing your lordship. Just to see.
Whether in the anywhere in that decision, dated 17/8/2009, Annexure 6, anywhere there have you used the word discretionary quota? No.
Because there is no concept of discretionary
quota at all.
At all. It is either under the law or not given or not given. So this matter was examined by bench of this honorable court, and your lordship
they held in your favor.
Yes. This
is in other matter.
Other collateral matter. Paragraph 8.
Covered by this judgment.
Yes.
I will say the subject matter
covered by this decision. Consequent upon that, my lord, government in GA department relaxed the condition of task force and release you. That is what instruction I have given. I believe that.
Now relief is granted to him.
Relief can be granted to him subject to condition that he should file an affidavit and all.
Whatever compliance
is required.
Then I will say that.
That's it. And a time limit for execution.
Yes, very much.
Because I have been running.
Very much.
I will record your submission.
Well, this resolution is.
Because resolution is there, my lord, government resolution. I
can copy.
Yes.
This resolution actually says that the restriction will not apply to single allotment.
It is also a single case.
My submission is it is not a discretionary quota.
Even otherwise you have
also.
Paragraph 8,
Petitioner, now please kindly be seated. I have understood your case. Petitioner, a retired judicial officer. A retired judicial officer is invoking the jurisdiction of this court for laying a challenge to the order dated cancellation, which is that order. Kindly be seated and answer. You are all senior members. I feel embarrassed when members of the bar stand up. I am far with
it's
you.
a matter of practice and habit, so it's like, Lordship may kindly pardon.
Very good. Then the order date is?
Order dated 3/9/2015.
3/9/2015.
That is the show cause notice under Annexure 1. Show cause notice under that.
Petitioner is knocking at the doors of the court with the following. Yeah. Okay. The essential grievance of the petitioner is as to the threatened cancellation of the allotment of the site, which he got pursuant to the coordinate bench order dated 17/8/2009, entered in his earlier WP 11423 of 2005. A copy whereof avails at Annexure 6. Next paragraph. Though the case has a checkered history, it need not be reflected in this judgment in view of the policy resolution number 35008 dated 8/12/2022, relevant part of which reads as under. As rightly submitted by the senior counsel appearing for the BDA, BDA.
They use the words fair means. That means by a virtue of court order.
Court order, it cannot be fair means. Reproduce it fully. It's agenda. Next one. In the light of above development, now only a period has to be prescribed for execution of the subject to execution and registration of conveyance in favor of the petitioner, subject to he complying with the usual requirements. Now, within what period you will comply? Within what period you will execute?
1 month it is.
Now, 2 months or 1 month doesn't make any difference for the reason that Honorable High Court said in a division bench that yes, whatever stamp duty and all these things, that will be upon the value paid to the BDA, not when it's present valuation, benchmark valuation. Correct. That will not cause any harm if some more time may be given, because I know that the BDA and all these things.
No, again, he coming here one more.
No, not necessarily.
He was earlier. He's a judicial officer.
Right. He was.
Let alone.
With due humility,
judges we should do the justice.
But with due humility, matters, I was the counsel in that case also. I went with that purpose committee.
He was the Registrar General of this act.
I went with the total committee and I saw that he should get a plot there.
Anyway, now we are asking you, within what period?
He
all compliances.
Not within 3 months. Within 3 months, may mention.
Petitioner.
So it can be done.
Will be complying within 1.
Petitioner submits that all compliances he would do within a period of 1 month, reckoned from this day. In terms of that resolution.
No, this is actually
formalities.
Your Lordship sees
usual formalities.
May one thing, Lord.
Yes.
Lord, what does he want actually? Because the resolution says for transfer of such allotments in favor of legal heirs of original.
No, not legal heir. In this case, legal heir
doesn't arise. So therefore, what is the requirement? Let me don't follow.
Requirement is what affidavit.
No, if you tell that,
I will tell.
So let them communicate.
To facilitate such compliance, the OPBDA shall, within 15 days from record from this day, communicate in writing to the petitioner what all are those usual requirements which the petitioner has to comply with. First, after the petitioner complies with the formalities and formalities as indicated to be indicated by the BDA, the necessary conveyance in favor of the petitioner shall be executed, duly executed and registered by the BDA within 1 month, perhaps? Within 1 month.
Within 1 month.
1 month. If you do not do, what should happen?
Obviously, I am violating the order of the Hon'Ble Court, my lord.
No, again, he need not come here.
He should not.
In the event, this the BDA fails to comply with this mandate, he is the head of the BDA, commissioner or who is
Vice chairman, but secretary usually does it.
The secretary shall be liable to pay a sum of rupees 2,000 per day personally and from his pocket, which he may recover from the erring officials in accordance with them.
Erring officials committing such mistake.
Therefore, we have said, every day 2 rupees they will get. You can delay, you can ensure them saying that I will give you 500. So 1,500 you remit to me or speak for 1 year.
Judicial officer, it is his interest, he should complete it without.
Yes.
No, it's not.
It's not. This is the best way to avoid litigations. Otherwise, cases will file upon contempt, first contempt, second, your concept, na? 3-tier system, first contempt, second contempt, third contempt. Then contempt law starts.
Well, sir, these wells, in respect of so far that particular part is, even if a word is written that it will entail contempt, so much contempt, that also do and they do it.
That is not necessary at all. Let him pay 2,000 rupees from his pocket. He will be very happy. Yes. Per day. It will be 60,000.
I think, well, sir, I know him personally, because I have appeared before him many times. You will not be thinking about getting 2,000 rupees.
Such a judicial officer.
You will not be requiring that. His son is also a judicial officer.
Yes.
Item 34.
Yes.
Item 34, my lord. Item 34, the state review petition, but the point is involved that the review against the order passed in an FTO 24C is not maintainable. That's the point involved here.
We have heard
You
that
Lordship, yes, hearing, and perhaps tomorrow that batch is coming.
I will come
next week.
when that matter is posted.
Perhaps
It
tomorrow.
was posted today, but somehow it has not come.
That also was posted today.
Yes, sir.
That is on maintainability.
Yes.
All right, we'll call this matter along with the WP number, along with our same day. All this matter. When WP number, RVWPET, 2011 matter.
Yes,
Do you have that number?
34.
No.
Yes, 234.
Of 2011. Because I was seeing how many years have lapsed, which Dash had argued other day, na? Mishra and Das.
Mr. Rautray and
Rautray and Das. All right, we will call this matter next week so that we can fix the date. Call this matter next week at the request of both. Yes. Yes.
Item 35.
35, my lord. The lordships wanted to know the ITCO Act. Actually, the lands were allotted to me by ITCO. That is the Industrial Infrastructure Development Corporation of Orissa, which is a statutory body. Your lordships wanted to know the
Give that time.
The rules are also there, my lords.
What is the judgment dated 25/3/2020?
My lords, my lords, the fact, initially there was an in principle approval of allotment of land to me for building a hotel, my lords. This was on, at running page 32, if your lordship kindly sees. On 18/11/2010, my lords, ITCO, I'm just placing the letter, subject in principle approval of allotment of land of Chandka industrial area on the basis of recommendation of DSWCA, that is the district recommending authorities, my lords, Department of Tourism and Culture.
1 second. Allotment letter dated, approval letter, approval to allotment.
Yes, my lords.
Pursuant to that allotment was done?
80, yes. No, pursuant to that allotment was not done. I'm just explaining. 18/11/2010, they gave an in principle approval for allotment of land of Chandka Industrial Estate on the basis of recommendation of DSWCA Bhubaneswar. Thereafter, this is given by ITCO, Odisha Industrial Infrastructure Development Corporation. Its duty is to balance lands are given to ITCO and they allot lands for industrial purposes to various people, my lords, various agencies. They also allot lands to Tata, the big corporations, even to government corporation, ITCO gives the lands.
Your lordship may keep it to 2 p.m. My senior
Senior wants to comment as you.
No, your lordship may pass it over at 2 p.m.
2 p.m.
Yes, Lord.
Okay.
Oblige.
Next.
Item 36. May I please? That this matter regarding refund of and the contributed amount of all alumni like the petitioner.
Wait, I'm trying to stand the prayer.
Yes, sir.
Refund of amount.
My lord.
What was that amount about?
Alumni, that the petitioner was an alumni, has contributed an amount of rupees 9,50,000 to the No College Abhijan.
Why it should be refunded to you? You have contributed.
Yes, sir. And I have earlier contributed 11,50,000, which has been utilized. That the petitioner feel that the amount which has been contributed by the alumni.
Under what scheme you had contributed this?
The Mo College Mo College Abhijan. Mo College Abhijan.
Where is that document?
Running page 40.
Who appears for the opposite parties?
Government as well as the private party principal.
I am appearing for opposite party number 4, the principal of the college.
You are principal of the college?
Miller.
Who should pay back?
Government should accord permission to refund amount. That is annex of.
Was it the refundable contribution?
Yes, sir.
Refundable contribution.
Running page 46. 46 should kindly see. Running page 46. 46.
Good, 46. The joint secretary to the government has already directed it.
Yes, sir.
Yes, you are not refunded. Your joint secretary himself has said that amount should be refunded. That was in 2023. Why you want to retain that money? What is the justification for the state king to retain the money of the citizen?
My lord. Whether that amount has been refunded or not,
there is an order 5/4/2023 by the joint secretary to saying that amount be refunded immediately pursuant to the order dated, the High Court order dated 9/1/2022. Where is that 9/1/22 order?
Lordship.
Why one more petition? You should have filed the contempt, na?
My lord.
Why, in that writ petition, were you a party?
Yes, I am the petitioner, Lordship.
You are the petitioner.
My lord.
Why again one more writ petition? Why?
Due to non-payment of the said amount.
But you should have taken action and proceeding, na?
Because in the meantime, the principal of the college, due to the inaction on the letter your lordship cited above, the government has a directive to take appropriate action against the principal. Therefore, principal has filed another writ application.
Writ petition is filed.
Yes, your lordship.
Saying
the inquiry has been made, and the inquiry in the present writ application, the petitioner also challenged the inquiry report.
Inquiry?
Annexure 11.
What inquiry was?
My submit, your lordship. Running page 61, your lordship. The finding of the
Mm-hmm.
61, point number 1 for 14 dollars, last paragraph.
They say you have to pay tax.
That is illegal, it's the same point. Contributed amount is lying on the Mo College applicant, may be returned after receipt of the. That is illegal.
Why?
Why? Because the 10 lakh in the year 2021, the principal has taken a hand loan from the petitioner, which has been refunded to the petitioner. That not is related to this case, your lordship. Then also, in this regard, I will say last occasion of the principal has filed an affidavit. Also, that amount is not related to the Mo College amount, your lordship.
No, but you are liable to pay 10 lakh rupees to the principal.
Not yet, lordship. See, that is illegal, lordship.
Why illegal?
Because in the year 2019, the petitioner, the principal of the college has taken the hand loan from the petitioner, 10 lakh, was rupees 10 lakh. That amount was returned to the petitioner in the year 2021. I again contributed twice, your lordship, 11,25,000, which has been utilized in Mo College official. There in the year 2022, I have again contributed 9,50,000. The petitioner returned the said amount of rupees 9,50,000 because the college has not properly utilized the contributed amount of the alumni, your lordship. Therefore, the government has inquired into the matter and directed to the return the said amount to the petitioner, which has been lying in the Mo College of Vegan, unutilized, your lordship.
Yes, sir. What is your stand? What is
my stand is at page 19 of my affidavit, my lord. And enclosure D, my lord. Page 19
of your affidavit.
My affidavit.
What you have said? Which paragraph?
Your lordship may kindly fill the last paragraph. Invoke the above fact and circumstance. I further request to kindly the principal has requested the joint secretary for accord necessary permission for refund of the amount.
If he gives permission, you are going to pay it back.
Miller,
you want permission from the joint secretary.
Joint secretary.
What is your difficulty?
No, the principal melody illegally transferred 10 lakh rupees to the account of the petitioner melody.
It is already transferred now.
Transferred melody. Page 61 melody. Page 61.
of the said inquiry report, my lord.
No, that is
Paragraph
a
two.
personal transaction
Yes, Lord.
between
My lord,
himself and
from
the
college
other.
account to the
It is paid from the college account only.
account, my lord. It's
You have received
college.
from the college account only.
College account, my lordship, the principal has returned my amount.
All right, but the college has paid you 10 lakh rupees. You only have to pay 50,000 back to the college and you institute proceedings for payment, whichever are the other proceedings. College has made the money, paid that money from the college account.
College account, your lordship, that for the inquiry report, but the college.
Not as per the inquiry report. That is transferred by check to you.
Paragraph 12, your lordship, running page 61, your lordship. Running page 61.
On verification of the bank passbook.
Yes, your lordship.
Had transferred rupees 10 lakh from college bank account to Miss Divya Jyoti Ray. 26/11/21.
21 years. That the petitioner, the principal in charge of the fault of the principal in charge, they return to my personal money. Thereafter, your lordship, in the year 2022, minor. In the year 2022, I contributed an amount, 9,50,000. Thereafter, your lordship.
You contributed
2021. Your lordship, 2021.
This 10 lakh was 9,50,000. 10 lakh was paid to you on
26/11/2022.
You were paid 10 lakh.
Yes, sir. Contributed.
No, 21. You were paid rupees 10 lakh on
9,50,000 dollars.
9 lakh 50. No. So Secretary College had transferred rupees 10 lakh from the college bank account to Miss Divya Jyoti.
26/11/2021.
It is 10 lakhs.
10 lakhs to 26/11/2021.
Correct.
I contributed.
You.
The amount of rupees 9,50,000 on 26/11/2022.
9,50,000.
Yes, lords.
What is this game of taking money, giving money? Is any business is going on?
No business, lordship. No business. The petitioner is fairly before your lordship. I have first contributed an amount for the development of college. I contributed 11,25,000, which has already been utilized. I have not done that, your lordship. When I found there were some dispute regarding expenditure of the contributed amount to the Mo College Division, therefore petitioner filed an application before the government to refund my amount to 9,50,000 as because the contributed amount has not been properly utilized by the college owners. Misutilized by the college.
Now this 10 lakh rupees was paid to you on 26/11/2021. Why it was paid back to you?
Because this fellow has taken an hand loan from the petitioner lordship.
10 lakh.
10 lakhs. See document I have also annexed.
What is your business?
No,
what is your occupation? Are you an income tax payer?
My husband servicing the amount which I wanted to development of my college.
How you got rupees this 10 lakh? Well, are you an income tax payer? Are you paying income tax? Have you reflected this money in your TRs?
10 lakhs your lordship, kindly see running page 49. Running page 49. 49 your lordship.
Money receipt.
Money receipt.
Now, wherefore you brought that 10 lakhs?
Well, the income of my husband, lords. The income of my husband.
Your husband's income is 10 lakhs. Then his income tax is payable. Where have you mentioned that you have lent this money to XYZ in your ITRs? In your returns, you have to reflect. If you have paid more than 15,000, it has to be by check.
Yes, sir.
Okay. You are saying how this money was paid? Rupees 10 lakh? And this is paid to whom?
The principal, Your Lordship.
You recover that money from principal by filing a suit. Why this money should be given to you?
That's the fault of the principal, Your Lordship. That is not fault of the...
No, you have to show to us that two things. Income tax rules say any payment more than 15,000 has to be paid by check only. But you have not followed that rule, number one. Number two, assuming that that rule is directory, where is the reflection of this amount in your ITR, income tax records? Number three, where from you brought this 10 lakh? You are not a businessman, not a builder, not a politician. Where from you brought this 10 lakh? No case is made out.
Take instruction from my client.
What instruction?
My client. From my client in this regard, Your Lordship.
All right. Reluctantly, having heard at length, reluctantly adjourned by 2 weeks. At the request.
In shape of an affidavit, Your Lordship.
I will direct Income Tax Department to investigate everything. Where from you brought that 10 lakhs? How is that you will give that 10 lakh rupees by hand?
Take some short time, Your Lordship. I take instruction thereafter, Your Lordship.
All right. Yes.
Item 37.
37.
Madam, petition is challenging Annex 10 of the rejection order. Madam, case
10. What's your prayer?
Only prayer is opposite number to not accepting my appointment letter. Appointment letter is direction to joining within 15 days, but due to illness and a serious illness is not joining within 15 days.
How many days you took?
2 months or 29 days.
2 months, 3 months?
About 3 months.
You took 3 months?
3 months. My Lord, kindly order dated 1/80/2025.
What had happened to you?
Medical certificate is attached here.
I did. No, what was the disease?
Fever of unknown origin. When a serious illness, medical certificate is Annex 5, page 15.
Annex 5, page 15.
15.
Medical certificate issued by whom? Dr. Bhagat Chandra Naik.
STS Rairam.
Yes, Mr. ASC. Whether that post is kept vacant or anybody is appointed to that post.
Well, on the last of your Lordship directed me to obtain instruction, but because of my mistake, a wrong letter has been issued by short adjournment, my Lord.
You issued an appointment order. Who will say no to the appointment nowadays? He had some genuine difficulty.
After a long span of time, he submitted a representation.
3 months. That's 3 months. Sometimes it happens. If a post is already filled up, I would have told him nothing can be done.
Yes, madam.
If post is kept vacant, then you have to honor the time prescribed for joining duty is not Sugrivagne.
My Lord.
Is it not? It is relaxable. It's a human problem. Bacteria and the virus, they do not obey us. We have to obey them.
Yes, madam. For 3 months, the
next day you ask your officer to accept the duty reporter.
Pursuant to my Lord's direction, I will get instruction.
Call this matter week after next at the request of the ASC. Yeah. Who will say no to job nowadays? Everybody is coming to court asking for job only. And he already have given the appointment letter. Some delay in reporting for duty. Maybe he is in seniority.
More than 1 year. More than 1 year. Yes, madam.
No, since that 2023 matter is pending. Such small matter, 2 minutes matter it is. Yes.
Item 38.
Other at the request of London ASC. Yes.
Item 38.
May I please allow? Yes.
Because the petition number 2 is a society. It runs a special school petition number 1. The special school in the sense that it is for disabled children. Now, it was established in the year 1985, got recognition, granting aid was released, and only after release of the granting aid, the all disturbance started. Now, OP number 5, she claims to be a staff school. Now, her claim, when the collector directed all the special school to make advertisement to fill up the post because 84 vacancies are available. Now, the secretary of the petitioner school also made an advertisement. That advertisement was challenged by the OP number 5 in this Hon'Ble Court, saying that I am a staff of the school, so there is no need of making an advertisement for the post of assistant teacher. Now, this Hon'Ble Court directed the collector to make an inquiry in presence of the parties and passed an order.
Inquiry happened.
Yes, and the inquiry without calling for the records, whether the main question, whether she is a staff of the school, whether there is a recommendation from the managing committee, and all these things, he relied upon the resolution of 2013, whereas 2022, that is, has been replaced by the resolution of 2022 guideline issuing regarding appointment, recognition, everything of disabled schools. Now, it has passed the order only relying upon 1 or 2 documents. Now, in support of her contention, OP5 submitted her document that she is very qualified. Annex 7 is the document issued by the Krishna University. It doesn't speak when the course was there, when it was issued, duration of the course, itself on the face of it, Annex 7, Krishna University, doesn't reveal anything about the course. This was suspicious. I made an RTI application saying that whether such an university has been affiliated. Now the answer was no.
University to be affiliated?
Yes, the university recognized. The university has not been recognized. I said that the university under the Andhra Pradesh, it has not been recognized. Then, he is my learned friend has submitted certain documents saying that the Rehabilitation Council of India has recognized the school. Now, she claims she was a student, regular student in the institute for 2 years. 2 years, and it's but the registration certificate that was submitted indicate that in 2021 the registration certificate was issued. Somebody takes in a college or university, the date of admission or the year of admission is that particular year. Not subsequently year of registration would be there regarding admission of a student. In any case, that is the case. Now my whole question, without calling for any records, without verifying the records of the school, without verifying the relevant rules, the collector has passed an innocuous order saying that she is eligible to be appointed as assistant teacher. She approached this university, approached this institute in 2007. By that time, she was BA. She doesn't have a special qualification, and the managing committee advised her not to come. She was never a staff of the school. By taking advantage of the president, some recommendation without the managing committee, some letters subsequently have been manipulated like that.
Whether our salary was paid by check or how?
No, salary has not been paid. She was never a staff. She never received any salary. Although granting aid was issued in favor of the school, she was never a staff.
Was it granting aid to the direct payment system?
No, they said that they did this granting aid in favor of the institute, and they asked for the staff, staff, their bank account, everything. It goes to the particular account of the employee. That is what they say.
You have not paid any money to her?
No paid.
At no point of time? No appointment order?
No appointment. She makes an appointment application for appointment 2021. Now she claims that I'm an employee of the institute since 2017.
Who appears for the other license?
Number 5.
Now, when were you appointed to the?
Your Lordship kindly asked to go to the impugned order. But the impugned order is
Annex 1.
Annex 1.
Page 19.
page 20, your lordship may kindly come, page 20. What collector has decided? Yeah. Page 20, paragraph 3. Besides, if there are no staff, if she is not a staff, why the president secretary of that school granted for training to the petitioner, and why they recommended the name of the petitioner before the collector by the letter number 9 dated 17/2/21.
This letter is, do you dispute this letter?
Yes, my lord, somehow, my lord, yes, the secretary dispute that, saying this was never a tool, but he has manipulated the letter, my lord.
Manipulated?
Either
No, what is meant by manipulate? Is it fabricated?
Not the signature, probably, not the signature. She said, the secretary said, might have taken the signature from the office or somewhere else. I cannot say that. But I have never recommended her name to the God.
What he says, he doesn't know. My lord, that
total false or true?
Totally false. The petition, why they recommended...
When were you appointed?
I was appointed in the year 2017.
17?
Yes.
What was your qualification at that time?
At that time, I was a graduate, simply graduate.
What was the required qualification?
Requirement is B.Ed, but at that time, when the B.Ed special training was not available by then, the management kept for the timing. Thereafter, management decided. Yes.
So you
I shall go to that.
No, you have to answer court's question first.
Yes.
Then you can turn the pages. You admit that you did not have the requisite qualification.
Yes.
In 2017, when you were appointed?
I was 21.
21? No, you said
21/6. I was appointed on 21/6/2017.
21/6?
2017.
Where is your appointment
yes, you order? Kindly come to.
Any appointment order is with you?
I shall show you. That is annexure E/3. Page
can we come after lunch?
Yesterday, your lordship was pleased to issue notice, special messenger notice to OUT.
There is some problem.
That's DR has blocked it. Let me deposit the special messenger notice. Let them come and say that this is not by single bench.
1 second.
But that should be intimated to me because it's on the read petition, phone number, enrollment number, and when we are just, my lord, your lordship only issued the notice. There is big due to urgency, and DR now blocked the file. The first time is surprising, my lord.
That's not
But I may be allowed to deposit the cost. So let it be.
To say a few words in response.
My lord?
Will you allow me to say something?
My lord, sorry, my lord.
Not to permit the justice.
Sorry. My lord.
Yesterday,
my lord,
there was a small meeting. In the meeting, it was pointed out that I could not have passed that order. Because matter lies within the domain of the division bench. Therefore, I have directed them to inform you and also to push the matter before the division bench. If the division bench, if they say that it has jurisdiction, it will entertain. If it has no jurisdiction, matter will come before.
That's right, my lord. But that has not been informed me so that I would have filed a second copy. That's the issue, my lord.
Now immediately you prepare second copy.
This without any intimation, there is no.
I have informed you.
That implies.
I have informed you do it. It appears there is some mistake from the side of yeah. Yes.
That matter which was possible.
Item 35.
30. Yes.
So, my lords, IDCO gives me a plot approval for a plot in principle. That is at page 32, my lords. This was given, as your lordships have said, notice on 18/11/2010.
Do you have a date chart with you?
No, I don't. I have not made it. If your lordship wants, I'll prepare a date chart.
Date chart would have helped me. You date chart also because some intricacies. For week after next. That's the request. Yes. In the meanwhile, date chart to be prepared with share with the other side as well.
I think a lot of this is
yes.
Item. Lordships are calling the matter on
After 2 weeks. Because next week no working.
No working.
Yes.
My lords, may I pray? I have some difficulty from 4th of September to, I think, 8.
Till 8.
Any day, yes.
I will on 11th of September. Then in the
11th.
In the third week.
Oh, third
week. Okay.
Oblige.
Item 38.
Find so many documents in its counter. It needs a comprehensive data. What I felt, we will ascertain the factor. So, your lordship, I pray for some time so that
At least next week
not possible. Week after next week. Yes. But you admit that you did not have educational qualification as on the date you were appointed. But anyway, we'll come to that.
That was at the time when the school was not recognized, when the school was not added. So qualification is not so essential. After recognition, that qualification is essential.
Item 39.
Yeah, but I need to clarify one thing. The matter was on 19th, before your lordship. On 18th evening, in the afternoon, a copy of the contesting opposite party, the municipal corporation, was served on us. Now, my municipal corporation,
what do you want now?
Now, I prayed for my associate on 19th, prayed for a deferment after taking CA Council and the Municipality Council, respectively, Lani Senior Mr. Dayanand Mahapatra and Lani Senior Mr. P.K. Mahanti. After that, so far as the private opposite party who lodged a complaint against me for demolition of my building, he could not be contacted, but after the adjournment was done, his associate, who happens to be his son, were intimated the reason of adjournment, namely that because the counter was served the day before, the matter was listed. After the matter
when shall we take up this?
So then they mentioned, after the matter was skipped because matter was adjourned from the beginning, my associate prayed for 2 weeks only. She was pleased to defer it for 4 weeks. Now, my land senior Mr. Sahu says that he was never intimated. By then, he was specifically not only intimated through message that it had been adjourned, the reason for praying for adjournment was intimated, namely, the counter was served only yesterday evening. I only pray for a 10-day deferment. Your lordship may take up in September 1st. That much, my lord. I am very sorry that an impression was given that I have not taken consent. You never do that. You never do that.
I am not entering into that controversy. Your lordship,
that was there.
Your lordship's last order.
Last order was that it will be taken up.
Your lordship,
that is true, but a counter came day before.
I have only mentioned before your lordship. The lordship passed this order. So therefore, the matter has been adjourned without intimating.
By then he was intimated. My senior Mr. Dayanand Mahapatra is there. My senior Mr. Pikaman, all were intimated.
The contesting opposite.
So sorry, my lord.
No, it's okay. I don't gather any bad impression about anybody. Anyway, this short accommodation we will give.
Yes,
I
am not objecting to short accommodation.
That's right. We'll fix a date also.
Yes.
On 3rd of September? Yes.
Ma'am, if you like, I am so grateful. Can it be on 9th?
9th of September.
I have some difficulty.
I have no stress. 9th of
As the last, I'm so grateful. I only want to clear the air that I never do that.
No, he did not say anything more than that. He did not mention any allegation. I have not
made any allegation against.
No, he did not say anything. I tell you the truth. I remember. In fact, 2 weeks was sought for. I made it before.
Exactly, you know.
It was never my practice.
But he also did not say any allegation, any complaint against any man. And that he said I ought to have been in man. In that one.
In fact,
That's
yes.
what he did.
Yes. You are informed post facto.
That's what.
But interim order may kindly wait.
Interim order to continue till then.
Grateful, man.
Yes.
Item 40?
Yes. May I please?
In this case, if I receive the parallel comment, I will file counter within a short time back.
Wait the counter.
My lord.
Lord, this case is squarely covered by the judgment of a coordinate bench. I have annexed that judgment in my.
Some short accommodation.
All right.
Within 10 days you file.
My lord.
This matter on 18/9. In the meanwhile, counter, if any, may be filed after serving a copy thereof on the council for navigation.
Yes.
Finally,
Interim order to continue.
Interim order to continue.
In all the two cases.
Yes.
Interim order is.
Why are you making haste? Do you have any interim order protection?
Well, the protection is there, but they are not extending me the benefit.
We'll call this matter on 26th.
26th.
26th. Okay.
In all the three matters, interim order is to continue.
Yes, in all the three matters, interim order to continue. If it is covered by the judgment, my lord, why you are taking time? Just ascertain it. Give copy.
I will give a copy.
Spain, Mr. Spain.
I will give one copy. Yes.
If the really covered by,
yes,
we should not unnecessarily take time. That does not.
The allotment was made some other councils of the panel. They had been to Puri with the. That's why some inconvenience.
No. If you want give time, I will give time. No issue. But if it is already covered by the judgment, in terms of that, we will dispose of the matter. Just look it. Let him take 5 minutes. Okay.
Yes.
Let him go. Yes. Pass over. Yes.
Item 41.
My lord, I have filed amendment petition.
Mr. Chief, just look into that judgment. You also just look into. Okay.
I filed an amendment petition. There is some mistakes so far as numbering of paragraph is concerned. After paragraph 9, it should be numbered as chronological number to the paragraph 19. That is the mistake I have done in the.
No problem. We will read it as a paragraph as you want. All right. Only paragraph number mistake, na? No issue. No issue. If your friend also is with that. No issue.
Another prayer is similar writ petition has been filed before this honorable court, and I am giving the number that should be tagged together and
call this matter with the WP number
21629 of 2024.
Week of the next.
September first week.
All right. Second week of September. Second week of September. First week we have difficulty. Today calendar heavily now. Yeah.
Item 42.
Yeah.
Notice was issued. And the counter has not filed till date by the BDI and as well as the CA department. Last occasion, Lordship has directed 17/12/2024. Your plot has already been allotted to me since 1982, but till date they are not talking over the possession of that plot.
Have you made any representation?
My lord, earlier it was disposed of with a direction to consider. Yes.
That's considered and rejected now.
Chief Secretary has decided that now BDO will hand over the possession.
Very good.
My lord, that is, BDA. That is page 66, last paragraph. But my read.
Let it, I got it, based on that page was not there, I got that page. Chief Secretary has already given a direction to BDA to hand over that.
Yes.
Probably, my lords, there may be some obstruction and something else, encroachment, anything else. I will take it, my lord, maybe taken up on.
They have in the meantime.
See that the actual things may be carried out.
No, where there is an order. Why to again, Arjun? There is Chief Secretary himself has said it.
Chief Secretary has not allotment.
Allotment has happened.
Now Chief Secretary has given direction. In spite of that, that was also 2000. That I will take note of minutes. I will immediately get that information. I will maybe taken up on week commencing 8th so that I can bring the detailed fact. Why it has not been complied with.
Yeah.
And in the meantime, they have taken the decision for alternative plot also due to encroachment. I have annexed all these.
You are agreeable with that?
Yes.
That is another concept.
Just looking. Call this matter on 8th of September.
I was anticipating that probably there must be some encroachment, something that is why some progress must be there because Chief Secretary
since 84 years.
Yes.
Item 44.
In that case, it was a rehabilitation assistance scheme. Actual appointment was there. There was a letter of the government at Annexure 12 stating that the contractual appointments made. Subsequently thereafter, the letter of contractual appointment was withdrawn because the 2013 contractual rule was written. My lord, they have said said that also in the letter at Annexure 12. The said circular was later withdrawn by Department letter number so and so dated 19/9/2020. The contractual appointment rules relating to RS scheme added educational institutions were not applicable. So the Odisha Group B, C and Group D was to repeal Special Provision Rules 2022. Will also have no application in the case of these employees who were appointed under Rehabilitation Assistance Scheme has been in effect within the period of 1/8/2009 to 9/9/2020. Therefore, when the repeal rules 2020 will not be applicable, those employees will be guided by the rules prevalent at the time of their appointment, which speaks of regularization after 6 years with remuneration as per the corresponding metrics along with the changes from time to time. This order is under challenge before your lordship. There, my lord, they are citing this judgment, but it is also they have taken care of to some extent. Contractual rehabilitation.
No, but the facts are completely same. The facts of this case, the fact matrix which you have now read out,
exactly,
they are absolutely same only.
My lord,
covered by the judgment. The subject matter of all these writ petitions is substantially similar to the one treated by a coordinate bench of this court in WP number
WP within brackets OSC number 2062
of
62 and batch of cases.
2007
batch of cases.
And batch of cases.
Between
Biplab Kumar Sahu versus State of Orissa and
others. Disposed of on
22/3/2023.
And therefore, the relief granted to the set of employees in those writ petitions has to be extended to the petitioners herein, submits their learned counsel. First answer. Learned AGA, ASC or AGA? ASC, having gone through the said coordinate bench judgment, in all fairness, submits that substantially the version of petitioner's counsel is true and the first one. Next paragraph. It is a cardinal principle of administration of things that like cases should be treated alike, subject to all just exceptions. And no case is made out that would fit into such exceptions. First up. Next paragraph. In the above circumstances, these writ petitions are disposed of in terms of the order in the cognate case mentioned above, with conditions with that is okay. No. Give just a copy of that judge. Yes,
Only the cases are disposed of.
No cost. Yes.
Item 44.
May I please answer?
Yes.
Here, my lord, this petitioner is the second journey to this honorable court on the prayer for stepping up her pay at par with her junior. Earlier occasion, since the prayer of the petitioner was by the director, saying that RSCP rule does not provide any kind of step up, that was challenged, and that the dishonorable court by the order at page 35 of my brief, annexure 6. The operative portion is page 37, your lordship can have a glance. Sorry, page 36. I'm reading from the beginning. In the year 2006, as per the commission, the pay of the petitioner was fixed at 11,260, whereas the Pradeep Kumar Pujari was fixed at 10,980 on 1st January 2006. But after increment in February 2006, Pradeep Kumar Pujari got higher pay at 11,440. Whereas the pay of the petitioner remained 11,260, even though she is senior to him. Further, in 2016 7th Pay Commission, the pay of the petitioner as well as Pradeep Kumar Pujari was fixed at 56,900 on 1st January 2016. But account of his increment 2016, again he got higher for 58,600 from February 2016, whereas the petitioner got the same pay of 56,900, even though she is senior to him. The rules for increment antedatation clearly provides that if a junior government servant get more than senior due to grant of next increment in the revised structure, in such eventuality, the increment of senior shall be antedated or the pay of the stepped up to that stage of a junior. The next increment of senior after...
So having observed all that, they have remitted the matter for fresh consideration.
And now this very same order has been passed that RSCP rule does not permit for stepping up pay. So what has been quashed earlier, that order has been reiterated again.
But that the RSCP was it there also?
Yes.
Where is that?
My lord.
In that order, whether the RSCP rules are not applicable, is it mentioned here?
In the present impugned order, your lordship?
Yes.
Yes.
No, not the impugned order. In the judgment of the coordinate bench.
Yes, that is there. First. My lord, said what I was reading is a letter to that. Representation, the same was rejected while order dated 14/12/2020 under Annexure 1 by wrong provision of law with regard to RSCP, which was not the claim of the petitioner. Thereby, this court is of the considered view that the order dated 14/12/2020 under Annexure 1.
How can you duplicate the same order? No. Who appears? You have duplicated, your client has duplicated the order which has been set aside.
We have not yet received counter in this case. Let's may 2 weeks for filing counter. 2 weeks.
My lord, kindly see the order dated 2/12/2024.
2 weeks, 24 man.
Only two, sir.
That weak rule is very weak. Nobody follows that rule. Within 1 week, everybody has to find the objection statement, counter. But it is very, very seldom followed.
You are practicing other rules.
Therefore, I said it is a weak rule. Second week of September. You could not have duplicated the order. At least you should have addressed that.
Yes.
Yes.
Can it be date?
We have difficulty. If it does not come, you move. I will remember. Yes.
Item 45. May I please? May I please, Your Lords? Your Lordship.
Whether
yesterday I just received the counter, Your Lords.
Received the counter
Yes,
yesterday?
Your Lords. Yes.
Okay.
So may I place Your Lords in this matter?
In the third week of September.
With Your Lordship's permit, may I?
You will argue the matter now?
Yes.
Or if they are ready, because some demise happened in the government.
That I understand.
Yeah, ask Arasumdare will coming week after.
Next week, that's Your Lords.
Next week?
Let it come on next week.
Next week only 2 days are working, na?
Week after, Your Lords. Lordship, I pray Your Lordship kindly fix a date.
No, date need not be. If it does not come, mention to. Yes.
It's a very year-old matter, Your Lords. Since the petitioner,
2012 matter.
No, what happened, Your Lordship? The petitioner challenging since 2009 before the tribunal, Your Lordship.
Call it 22nd of September.
Grateful, Your Lords.
Item 46. My Lord, here.
Yes.
An advertisement was floated for appointment of teachers to the secondary school. My Lord may kindly now turn to the advertisement for a moment.
What is your prayer?
My Lord, I have prepared in this way. If your Lordship will permit, I'll just
let us read the prayer, then we can go.
My Lord, I have prayed. Here what has happened, my Lord. There were posts of 1896 posts.
Selection procedure as
One paid for flushing of the
preliminary result of preliminary examination. The direct opposite parties to conduct separate preliminary examination, which will publish separate selection list. Yes.
My Lord, may kindly turn to Annexure 1.
Annexure 1.
My Lord, here what had happened, my Lord, total 1896 posts were advertised to fill up in TGT Arts.
1896 posts.
My Lord, at page 17. My Lord, first serial, TGT Arts, 1984. Thereafter, my Lord, after the advertisement, they issued a corrigendum. The corrigendum, Annexure 2, page 32, wherein they took out 25% of those TGT Arts teachers to have TGT Odia. From the 1894 seats, 25% was taken out. My Lord will kindly see at
they became 1488.
Yes. My Lord, 496 seats. That below your Lordship will see.
Correct.
My Lord, here now Lordship may kindly turn to the advertisement for a moment. Qualification, which was there in the advertisement.
Annexure 1.
Yes.
Page number 15.
Yes. My Lord may see the advertisement.
That page number?
My Lord, page number 20. My Lord, may I read it as a whole for assisting your Lordships properly? TGT Arts, Bachelor degree in Arts, Commerce or Shastri, Sanskrit degree from a recognized university with 2 school subjects. School subjects as defined in the proviso hereunder from recognized university having 50% mark in aggregate, 45% of subjects relevant. Bachelor in Education, B.
And Bachelor in Education.
Yes. 3-year integrated BEd, MEd from any NCTE recognized institution, or 4-year integrated BA BD from NCTE
recognized institution on the two school subjects such and such 50%, provided that in case the candidate must have passed the bachelor degree from any two schools, subjects offered as pass, honors, elective, optional, compulsory, foundation subject out of the following: English, ODS, Hindi, Sanskrit, history, geography, economics, political science, Indian economy, landmark in Indian history, Indian geography, Indian business economics, and communicative English. This was the criteria.
What is this provided?
Along with, your lordship may kindly turn to page 20.
No, I have not understood this. What is the proviso?
Provided that in case the candidates must have passed bachelor's degree with any two school subjects.
Must have means? Must is to be removed or what? They must have, but they have not.
No, they have to pass this.
Because there is a chance of happening.
Here what has happened?
So it must be in any case the candidate having bachelor's degree with any two school subject. That
Yes. Now your lordship may kindly see page 23. Paragraph 6. The candidate must have passed Orissa Secondary School Teacher Eligibility Test, that is OSSTET, in concerned category, concerned subject, conducted by Board of Secondary Education Orissa. So this was also a part that along with that, this should be done. Graduation, BS, B.Ed and OSTT.
Yes.
Am I clear, madam?
Yes. This is additional qualification.
This is a mandatory requirement.
That's fine.
Yes.
Additional. It may be mandatory.
What happened, madam? After the seats was created, they carved out a corrigendum, annexure 2. Bring out 25% of those posts and create a TGT ODIA post. Trained graduate teachers of Odisha, ODIA medium. ODIA language. Your lordship may now see the qualification of TGT ODIA. That is at page 34.
34.
TGT ODIA. Last, madam.
Minimum educational qualification.
Yes. Bachelor's degree in arts with ODIA as a subject in honors, pass, elective with minimum 200 marks, excluding compulsory ODIA subjects. Because ODIA subject is compulsory here.
That will not be sufficient.
No. From any recognized university with at least 50% mark in aggregate and BEd with such and such from any NCPE recognized institution.
Yeah.
3 years BEd is not available in ODIA.
In Orissa, it is not available.
Yes. Now your lordship may kindly turn to the next page at page 35. 4-year integrated BA BEd from OR. This is OR is there, madam. At the top, your lordship will see. I read the qualification, then OR 4-year integrated BA BEd from any NCTE recognized institution with ODIA as a subject in honors, pass, elective with maximum. Then with at least certain equivalence in bachelors of education in special subject, that is Hindi, Sanskrit, Shiksha Shastri, Telugu, Urdu, special any other special subject shall not be allowed for the post of TGT ODIA.
Equivalence is not possible.
And in this TGT ODIA, OSTT exam is not there. So my humble submission before your lordship that this creation by a corrigendum is ipso facto illegal, because that condition in paragraph 6 on the first advertisement, clause 6, that he has to pass OSTT examination cannot be here because there is no such examination for TGT ODI. The very issuance of corrigendum, bringing out 20% seats from the secondary school advertised is itself wrong.
Why?
Because in the counter they have stated this fact. My lord may kindly see the counter filed by OSSCC, Orissa Staff Selection Committee.
Which paragraph?
Before activation of online application, the Director of Secondary Education RA by their letter number such and such had intimated that School and Mass Education Department OP number 1 has decided to earmark 25% out of TGT Arts post as TGT ODIA post. That is 496 post out of 1984 TGT Arts post. The RA further requested to create provision for inviting applications for TGT ODIA through online without providing any detailed criteria for TGT ODIA. Based on the above instruction, the Commission published a notice regarding postponing the date of inviting online application. They take up their hands, madam. They say, as details are not there, we are postponing. Now what has happened? Madam? This TGT Arts person who have applied for TGT, they were given option of applying in both the categories, TGT Arts and TGT ODIA. Suppose a person gets highest in TGT ODIA, in TGT Arts, he gets an automatic entry in TGT ODIA. Because it's a combined examination, one paper was there. And by that process, what he does, madam, he blocks one person from entering into the fray. Those have only TGT ODIA, they cannot enter into the arena of consideration. If they would have made two papers, bifurcated them, then matter would have been different, madam. Here, state has not whispered a single word by filing any counter.
But it is state which directed year of 25.
It has done it. So state has to justify what basis they did it.
OPSC will say we are following what the state has done.
So OPSC now puts their hands back saying that, sir, it is not there. So how can we do?
At least OPSC ought to have written to the state. But by virtue of your decision, all these problems will crop up. Unless you do a comprehensive decision, it is very difficult to implement this.
My lord, in this case, my lord, the argument of my lord senior, my lord, actually it has been presented in a manner, my lord, it is not in the prayer. However, my lord, because we have filed on counter, just to give the factual backdrop, my lord, this case. First advertisement was issued on the basis of the requisition what we have received from the department. Later on,
you received the corrigendum. Addendum.
Yes, ma'am. Later on, a decision was taken by the state, my lord. That is annexed E by 2 our counter at page note 42.
Therefore, state has to answer that, not you. The problem which otherwise, one candidate is blocked permanently because of this addendum.
Well, only one submission, my lord, in this case. After this addendum, a corrigendum was issued, a new notification, a subsequent notification advertisement was issued, reclassifying the post from TGT Arts, an independent category TGT ODIA was indicated. Thereafter, the petitioner applied for the post. And after participating in the selection process, when he got unsuccessful, thereafter he had applied.
My lord, there are judgments of the Hon'Ble Apex Court. My lord knows that. I need not place it.
Not yet completed, my lord. Only one more submission, my lord, with your lordship's permission. Now, my lord, it has already been presented before lordship the prayer. Nowhere there is a whisper in that particular prayer saying that, my lord, categorizing a particular portion, that is 25% of the post
is bad.
Of the TGT ODIA, that is bad. There is no decision of the government is not on the challenge. It is the only decision of the OSSC to prepare two separate lists for the TGT ODIA and the TGT Arts. That is on the challenge. So, who appeared in the selection process and could not succeed in that particular shortlisting process, after appearing in the examination, now she is before your lordship, saying all these things.
You participated in the process.
Yes.
And you failed.
Yes.
Thereafter, you are turning around.
Yes.
How?
My lord, there are judgments of this Honorable Court, of the Honorable Appeals Court, which says, suppose I challenge that. It is not mandatory that I accept it. When the anomaly is there, my lord, a person is deprived, your lordship may kindly see that judgment. See judgment again.
No, you should have at least pointed out. I will participate to reserving my right to challenge.
My lord, mere participation does not ipso facto debar me from approaching the knock the doors of justice.
Generally,
That is the view of the Honorable Apex Court. Your lordship may kindly see this.
no. The general rule is,
yes,
throughout,
yes,
for half a century jurisprudence,
yes,
is once you participate,
yes,
you cannot turn around and take challenge.
Yes,
especially having lost.
Yes, my lord, that was the point where Honorable Apex Court decided this judgment. My lord may kindly turn from paragraph 17. Reference, Major Meeta Sahai, Dr. Major Meeta Sahai versus State of Bihar. My lord may kindly see paragraph 17. It is well settled that the
then go to next.
Yes.
The underlying objective of this.
The underlying objective of this principle is to prevent candidates from trying another shot at consideration and to avoid an impasse wherein every disgruntled candidate having failed the selection challenges it in the hope of getting a second chance. However, we must differentiate from this principle insofar as candidate, by agreeing to participate in the selection process, only accept the prescribed procedure, not its illegality in it. In a situation where a candidate alleges misconstruction of statutory discriminating consequences arising therefrom, the same cannot be condoned merely because a candidate has part taken in it. The constitutional scheme is sacrosanct and its violation in any manner is impermissible. In fact, a candidate may not have locus to assail the incurable illegality or derogation of the provisions of the Constitution unless he or she participates in the selection process.
Now, had you succeeded,
yes,
would you have come here?
Yes. No.
You would not have come here at all.
No. Your question is your lord.
So, after having lost the battle,
yes,
you are here.
My lord, why I am here?
Challenging the battle lines themselves.
Yes, my lord, why I am here? The question is, your lordship may see. By this process, your lordship may kindly visualize this situation. That TGT Acts candidate who will get the highest will automatically qualify for TGT ODI. And ultimately, when the final stage comes, there will be a huge vacancy. And the persons who could have been eligible for the post will be out of the fray. After 6 years, this advertisement has been issued. The efflux of 6 years, my lord, many candidates have become overaged. It's a government appointment. After 5 to 6 years, they make one advertisement. And with this anomaly, my lord, intend to discard many intending persons.
But that ground you have not taken up in the.
No, that we have taken in the prayer, if your lordship may kindly see.
Yes.
I have prayed.
That prayer also. For prayer, ground should be made modified as ground. They exclude particular people.
After receiving the counter, I have filed it. We have taken and we have also given in the rejoinder that this is the problem.
Why? How government would be benefited by excluding a set of people?
Yes. My lord, when your lordship may kindly see one thing.
Indeterminate. Government will not be knowing who is what.
No. Your lordship may see other aspect. What will happen normally? When a pupil passes a school, enters the college.
Anyway, this requires counter from the state.
Yes.
Brother G. Your counter is required. Generally, we will not direct the government to file the counter. But in matters like this, there is some warrant for requesting the government to file the counter.
Will file value?
Yeah. Because on technical grounds, there is some practical problem now. Because of addendum, the practical problem has arisen. And many who otherwise would have been entitled to selection, they are blocked. And these are not periodic. There is another problem is, periodically you do not take up recruitment process at all. You wait till many thousands of people become yes-barred. Then one fine day you will issue the notification. All these people will lose. And you do not make a provision saying, all these years we could not issue notification. Therefore, for these years will be minus while computing the age of the candidates. Even that fairness you are not showing.
Relaxation of age.
Yeah, you do not, many thousands of candidates who are otherwise maybe board members, first rankers, maybe most meritorious, who are hoping that one fine day government would issue notification.
There is a
they
rule.
will be rendered ineligible.
There is a rule for relaxation of age of 1989, upper age limit.
But in this you are not adopted.
That portion, section 2 has been deleted in the year 2011.
Then that amounts to greater injustice. What should happen to those? Because you cannot prevent, we can't give interim order staying the aging. Unfortunately, we cannot issue any interim order against Brahma that the aging process should be halted. That's not possible.
Your Honor, there is a relaxation up to the age of 38 years.
Age of 38. Which
32, my lord. Now it has been made 42.
42.
In the present scenario, my lord, now the rule has...
Age is 42. It is amended.
I mean...
Upper age limit.
Upper age limit is 42.
42.
So there is a statutory rule, my lord.
Correct.
To that extent, my lord, government has relaxed that particular rule, my lord. Now,
to that extent, hardship is mitigated. Is your
in 42. But in the present advertisement, when it was issued, at that time, my lord, it was taking into consideration the number of years the advertisement could not be made, but it has been made 38. It is a pen or 16 of the advertisement.
Which would be 32.
32.
That
it was extended.
That aspect is taken care of. Then I start correcting.
Government has actually taken a decision to that extent and accordingly made a requisition to us, my lord, and we have done.
Page 16, my lord. Page 16, your lordship, I kindly have a look. Page 16,
para D, the first line.
Top of the...
Where it is mentioned.
The prescribed age limit for post is 21 years to 38 years.
21.
21.
21 years.
21 years to 38 years as on 1/1/24 with usual age relaxation SC, ST, SC.
No, otherwise 32 years.
32 years.
He is right in correcting me. Because they have said, instead of 32, it will be 31 years.
Correct.
That period is covered.
Correct.
So anyway, that will not be an issue. But your counter is expected.
I'll give my lord. School department.
Whether this is finalized now. Process is finalized.
There is an interim order by your lordship.
Interim order should continue. Call this matter on 24th of September. First half. Till then, interim order to continue.
46.
Yeah.
Here what will happen, your lordship can see. The person who gets the highest in TGTRs gets an automatic entry in TGT. By that manner, if TGT would have been different, then it would have been a separate paper, separate list, separate candidate. I was given option of two categories. I opted for 2, and once I get highest, I get automatically in the second. So I block another person's entry.
In cottage.
It would have been an independent procedure.
Let us see. No parallel of this kind of how courts have treated this issue.
Yes, actually, I could not place it, my lord.
There are judgments.
No, there are judgments also, my lord. We have also discussed in our counter that in fact the chances of even getting considered or being selected, my lord, that has also not been prejudiced, my lord. Reason being, we are not actually taking 1:1. we are actually taking into consideration 1:5. Even the petitioner could not succeed within 1:5 even.
But that will not answer the point which he is raising.
But that is what he is precisely making a submission that selected in TGT ODR because there is a clause available in the advertisement itself that he has two options. He has the option to give 2 posts.
Yes.
And accordingly, he has opted for TGT Arts. So the same roll number, my lord. He has annexed a select list of 2 categories, preliminary research select list of two categories. There he is making a submission that about 600 some odd persons who are figuring in one set of selected candidates, they are also duplicating in the other selected candidate. That is the reason for which some more person would have come had there been not an option of giving the second 2 persons, 2 sets of posts. Our submission that is a condition in the advertisement itself that a person has the right to apply for post. And accordingly, whoever has opted for the same, accordingly his name has been considered. Now, hypothetical matter, if X has applied for TGT Arts and TGT ODR, and because of his good mark, he is figuring with TGT ODR, can we say that your name will not be figured within the TGT ODR? That we cannot say. So his name is obviously also occurring in TGT ODR figure. Now he is making a submission that because his name is also available in both the categories, so actually I am deprived of getting it.
May not be correct at all.
That is what my lord, our submission.
My lord, one thing, your lordship. With due respect to my learned senior.
Anyway, what we say is you reserve some argument.
Yes.
So that they find the objection.
Your lordship, kindly note this in your lordships. I know your lordship very sharp memory. Your lordship may kindly note. What will happen now? This person gave in one paper, they gave examination, they gave in arts, they qualified in ODR. Now what will happen, my lord? These advertisement, what they have mentioned the criteria, where they will make verify the records. They will verify the record when the final selection is made. In selection, this what I demonstrated before the lordship, such examination is not there in Odisha. They will discard everybody. There will be vacant post. Now, when a pupil joins a college, at the threshold his credentials are verified. Why not verify the credentials at the threshold? Why they wait for the last run? When a person has run up to 300 meters, in 400, when he's running the next 100 meters, they say, sir, wait, your shoes are not there. You are not holding the baton. Is it a way by the deprived persons from getting jobs?
Let us see. There are some points which he is highlighting. Suppose a particular degree is not available at all, the one which you have prescribed. Such courses are not available at all. Where they should go?
My lord.
That aspect is also there.
Yes, I will take care of in the next counter.
You just look in. There are English judgments which say an impossibility of performance should be treated either as having been waived or as having been complied with. In fact, Maxwell on interpretation of statutes refers to that maxim, which he has borrowed from Broome's legal maxims. I don't remember that Latin maxim. Impossibility of performance. Just look in.
My lord, I will take care of.
Grateful.
Item 47.
May I please your lordship?
Yes.
This matter, the present petitioner, let me give the big fact of the case, lordships. This is in regards to the appointment of...
Let us see your prayer, how you appoint your prayer.
Page 9.
Very briefly, very concisely how drafted the prayer. Rarely I come across such drafts.
This direct opposite party number 3.
Direct them, sorry.
Coordinator Baleshwar to publish a press notification recommending the name of the present petitioner under the heading of untrained applicant for the Sikha Chaka for the year 14 and 15 in the district of Baleshwar.
Baleshwar to issue appointment letter as per the guideline of Shiksha Sahayaka holding by order dated Amuka as illegal.
Mr. G, are you ready?
As illegal. Lordships, this Shiksha Sahayaka appointment is based with two qualifications. One is OTT 1, another is OTT 2.
OTT
1 and OTT 2.
These are the qualifications.
These are
Orissa teachers eligibility
this
test.
is called OTT, Odisha Teachers Eligibility Test.
One is meant for
TIT.
Odisha Teachers
Orissa Teachers
Eligibility Test.
OTET.
For Shiksha Sahayaka, OTT is a must. OTT qualification is a must.
Yes.
Now let's see. A candidate who passed OTET 1 shall be appointed under city category.
Please repeat.
A candidate who passed OTET 1.
OTET 1. There is another OTET 2.
OTET 2 I am coming. It will be eligible for
Shiksha.
City category. City category. City category. And who passed OTET 2 will be eligible for BEd category. Bachelor in Education and city is teachers in. Now, my client, who is a OTET 1 passed, having BEd qualification, applied for the post of city category.
City category.
Since she is a...
There are two categories. One is city category, another is not city category.
No, BEd category.
BEd category. BEd. Okay.
Now we are calling it BEd. Now, Lordships, my client, she is OTET 1 pass. Means city category.
Yes.
Having BEd qualification.
OTET 1 with the BEd.
BEd qualification. Made application for city category. She was selected as trend category, under the trend category. I'll come to documents. Thereafter, on scrutiny, she was taken under untrend category.
Selection was as trained category.
Selection was for trend including all.
All, okay. It's a common selection.
Common selection. She was selected and her number was found placed on the trend category. Now, on scrutiny, they found she is not on a city pass. She is not a city pass.
Therefore, she has been put into
untrained category. Now, she has put in untrained category in a serial. Thereafter, they did not give her appointment under the untrained category. Now she wrote a letter to the authority for her appointment. Authority rejected it.
On the ground?
On the ground that since you have applied for OTET category, OTET 1 category, you are not a city candidate. Therefore, you cannot be observed for city category post. Now it was assailed before this Honorable Court 2-3 occasions. The last occasion, this Honorable Court passed an order directing the general instruction issued by the government for the appointment of the Shiksha Sahayaka of the year 2014 and 15. Clause 7 has to be taken into consideration, which says a BEd candidate can also apply
for the post of city
trained category. City category.
For the category, if she or he is qualified under OTT 1. Pursuant to which this Honorable Court gave a direction to the authority by the rejection order passed by the authority and remitted matter back to the authority by saying, declaring that strictly follow the general instruction issued by the government. Now authority rejected the same by saying, since you are a BD category, BD qualified, you are not eligible to be
OTET 1 coupled with BED.
BED. Now, Lordship, for that purpose, kindly come to my application.
Yes.
Paste. This is at page 30. Lordship got it? My application?
Yeah.
Form for application for the post of Shiksha Sahayaka city. This is my application.
Yes.
Now, Lordships, thereafter, the general instruction, which is I am going to have, general instruction, page 23. Lordship got it?
Yes.
Applicable for OTT qualifiers only. This is my client has passed OTT 1. OTT 1 passed candidate can apply for city category.
And OTET 2 passed candidates can apply for BEd category.
BEd category. There is no impediment, Lordship, that except qualification prescribed under OTET 1 or 2, they are not prescribed any other qualification, city or BEd. As because why I am harping this, after appointment, one can go for training, for city training and BEd training. That is prescribed here also. Now, clause 7 says, Lordships, which I am harping, OTET 1 pass, clause 7.
Yes.
OTET 1 pass, that is what I am just, OTET 1 pass untrained.
SC,
ST and physical handicap. My client is physical.
They can apply, but you do not fit into that category.
I am physically handicapped. Kindly come to.
Handicapped.
Yes, Lordship. No doubt about, no dispute about that. Lordship, then kindly come to the judgment passed by the Honorable Court. Relevant is as page 52 of the judgment. Para 4, Lordship. This is my argument before. Page 52.
Admittedly, petitioner is a graduate with BEd qualification and has passed OTET 1. Further, she belongs, being a disabled candidate, having hearing impairment, can be considered for city category support.
The BPC has not considered this aspect while rejecting
the
representation of the petitioner basing on the clarification dated so and so. Thereafter,
application which you read, that is clarification.
Lordship.
29/8/2000.
Lordship. Thereafter, Lordship's operative person at page 54, para 8. This is the Honorable Court's view.
What the court reading?
Para 8. May I read, Lordship?
It appears.
Lordship, it appears that by notification dated 11/9/14 of the government guidelines were issued for engagement of Shiksha Sahayaka, the advertisement under clause 7, which I was referring to, provided that OTET 1 pass untrained SC, ST, physical handicaps can apply for city post. it is not disputed that the petitioner was a physical handicapped candidate in view of the certificate issued by the medical
75%
lordship. The list of eligibility candidates originally published by the OPEPA, wherein the name of the petitioner is at serial number 191. Mentioned here as hearing impaired candidate. Though clause 7 was referred to
in the previous judgment.
The previous judgment passed by this honorable court. Yet the fact that the petitioner is a physical handicapped candidate was not specifically considered for grant of relaxation. The DPC, while passing the impugn order, has also considered the provision of relaxation for physical handicapped cats, which clause 7 I was showing to my lord. In the counter affidavit, it is simply been stated that in view of the rejection of the earlier writ petition, the question of considering the petitioner's case handicapped person does not arise. After going through the relevant clause, this court is of the view that there being a specific provision for relaxation meant for physically handicapped candidates specifically to the effect that the such candidates having OT to 1 qualification can also apply for city category post. This is very important. The same ought to have been considered by the DPC. For the foregoing reasons, therefore, this court persuaded to hold that the impugn order having been
all right. Why court did not grant the order directly? Again consideration.
Again consideration in view of the clause 7.
The clause 7 could have been applied.
Yes, lordship, it's lordship. What is coming to my lord's mind? Only I could argue before the court. Lordship, thereafter, then the rejection order.
That says page number?
Page relevant is page number 13.
In fact, your bar member should garland all our judges for giving so many causes of action, fresh causes of action.
But the only thing is depriving all lordships. We are belong to state of Odisha. The fees is very low. Otherwise, we could have become very rich by this process. Had it been Mumbai or a lordship state or Delhi, that's what we are so lacking. Lordship, kindly come to page 13, para 8. This is the DPC order. Very interesting, lordships. Where clause 7 of the general instruction for candidate OTT pass wanted candidate can apply city post, it clearly indicates that the candidates belong to SC, ST and physical handicap category who are untrained at the time of submission.
Where are you reading?
Yes, let's see, page 13. 1-3.
Item number? Clause 8.
Let's see.
Clause 8? No.
That is rejection order. Rejection order.
Clause 8, man. Clause 8.
Clause 8.
That's the question.
May I read? It will be convenient of my
very. You can read that.
Lordship. This is important as because that's I am taking pen, lordship. Whereas clause 7 of the general instruction for candidates states that OTT 1 pass untrained SC, ST and physical handicapped candidates can apply for city post. It clearly indicates that the candidates belong to SC and ST and physical category are untrained at the time of submission of application form can apply under untrained category. But in this instant case, the petitioner apply under untrained category having qualification BSc with BD. This shows that the present petitioner is a trained candidate. At the time of submission of applicants, the petitioner does not come under the...
You have specified in your application for appointment as CT.
This is city. I have specifically applied for city. There is no dispute. They say since you have got BD qualification, in spite of the order passed by this honorable court, you are not eligible because at the time of application, you are having BD qualification. But I cannot apply for BD qualification as because I have no PT1.
Yes.
Therefore, this order lordship is not sustainable.
How could this order be override the order passed by this honorable court?
It's a question to you. Yes.
My lord, Lordship had the general.
Paragraph 8 runs counter to the tenor of the judgment which he has secured earlier.
But Lordship, kindly have a look to the general principles, what it speaks. କେତେ ନେକ୍ସଟ କହୁଥିଲେ
ଆପଣଙ୍କର ସେଟା ପେଜ 23
general 23. 23. My lord, here
Paragraph instructions for candidates are annexed.
Candidates, paragraph 2. OTT 1, past candidates can apply for city category. Well, two types of candidates are there. One are city category and other one is B.Ed category. Because
what is that city?
City is certificate training.
Certificate
training. Certificate teachers training.
Certified
training. This education they are getting after +2, whereas B.Ed they are getting after graduation. Subject teachers are in B.Ed because after class 6 onwards, these teachers cannot teach there. Their subject teachers will teach. With that intention, at the initial level, entry level, city and B.Ed, both the candidates we are recruiting. My lord, these candidates, my lord, so OTT 1 past candidates can apply for city classification. Those who have passed OTT 1, those who have passed city qualification, acquired city qualification, they can apply for OTT 1. OTT per city, OTT 1, those who have qualified, they can apply for city category. Those who have qualified as OTT 2, they can apply for B.Ed category.
They are mutually exclusive.
Yes. They cannot apply. Suppose here, my lord, this
that is precisely my point. That is precisely my point. Rejection. While rejecting this,
my lord, let me please.
Again,
let's. ଯଦି କୋଉଠି ଭୁଲ କହୁଥିଲି ଆପଣ ରେକ୍ଟିଫାଏ କରିଦେବେ
ନା ନା ଆପଣ କଭରେଟ୍ କରିଦେବେ ଆପଣ ଠିକ ଅଛି ଆପଣ ପୁରା
my lord, as it reveals from the impugned order at annexure 1, your lordship.
Let us understand this. Clause 2, mutually exclusive categories.
Let's
categorize.
We agree with that.
Categorized.
One category excludes the other category.
Yes.
Excludes the other categories on the footing that a different category. It is different category. Only on
at least on that you are agreeable.
I am agreeable. Different category.
Give that
note 6.
Petition. Copy of the petition. Yes.
My lord. Thereafter, my lord, lordship may kindly have a look to the impugned order at annexure 1.
No, before that come to the condition 7, clause 7 of the general instruction.
Yes, my lord. In general, in clause 7, it speaks, my lord, the OTT 1 passed on trend, SC, ST, PH candidates can apply for city posts.
Yes.
My lord. OTT 2 past graduates for SC, ST, PH category can apply for B.Ed posts.
Yes.
Lordship. Then your lordship may kindly have a look to the impugned order at annexure 1, page 12. This order was passed pursuant to your lordship's direction in the judgment at
The other case.
yes, annexure
Earliest
annexure 12, annexure 11.
In favor of the petitioner.
Annexure 11, my lord. Your lordship directed to consider. They have considered the case and passed this order. Pursuant to the orders of the Honorable High Court. Page 12.
Page 12.
Yes.
Impugn order. Impugn order. Annexure 1, page 12.
That's one, page 12. So it is a CV Ram. This is the next one.
Annexure 1.
Pagination is not proper. I got it here. No,
my lord. Pursuant to the direction, I am placing that, my lord. So, directions, public orders of this honorable court, the representation of the petitioner has been examined by the opposite party number 3 and decided as follows. The petitioner was an applicant for the post of Shiksha Sahayak under city SCVC category for the year 2013-14 for Balasore district. On verification of the application form of the petitioner, it is revealed that the petitioner has acquired graduation qualification with B.Ed and passed OTET in paper 1.
OTET in paper 1 means OTET.
1. Okay. My lord, whereas the government of Odisha in School and Mass Education Department clarified in letter dated 29/8/2013 that a candidate passed OTET paper 1 cannot apply for B.Ed category post, and candidates passed in OTET paper 2
cannot apply under city category.
Under city category. That classification.
OTET 1 cannot apply to B.Ed category. B.Ed category. Sports
ପଚାରୁଛି ମୁଁ କହୁଛି ଆପଣ ମୁଁ କହିସାରିଲା ପରେ କହିଲେ ହବନି unnecessary confusion create କରୁଛନ୍ତି ଟିକେ ରୁହନ୍ତୁ ମୁଁ କହୁଛି ଧୀରେ ଧୀରେ ସବୁ କଥା କହିବି ମୁଁ ଭୁଲ କଥା କହିବିନି whatever there on the record I will speak.
Yeah.
That's it, got it.
Yes. That mutually exclusive one category, he cannot apply in the other category.
Other category.
That is your reason.
Here, my lord, he is having B.Ed pass with OTET paper 1.
Correct.
Had he been acquired city with paper 1, can apply.
He does not have city.
City. His B.Ed.
But he applied, his application was under city.
Under city category, OTET pass category.
OTET pass category.
OTET 1 category.
Not B.Ed category.
Not B.Ed category. Being an SCVC category. SCVC 1.
SCVC is OBC.
Yes. OBC. Yes. My lord.
Yes.
In paragraph 2, it has clarified that in letter dated 29/8/2013 that candidate passed OTET paper 1
cannot apply
B.Ed category of post, and the candidate passed OTET paper 2 cannot also apply under city category. The petitioner had no requisite qualification as per guideline prescribed by the government of Orissa in School and Mass Education Department. The candidature of the petitioner was rejected during 2014 recruitment process. After rejection of her candidature, the petitioner had filed writ petition of the Honorable High Court in WPC number 52 of 2015. And the said writ petition was dismissed by the Honorable High Court.
Writ appeal was filed
On 16/2/2016, being agreed by the order dated 16/2/2016, writ application was filed before the division bench. Writ appeal was disposed of on 7/2/2017, being withdrawn by the petitioner, giving liberty to the petitioner to approach the competent authority for redressal of his grievance. As per direction of the Honorable High Court, dated 7/2/2017, the petitioner submitted representation before the opposite party number 4, Collector Baleshwar, on 10/2/2017. And accordingly, the opposite party number 4 heard the petitioner and rejected the grievance of the petitioner being devoid of merit on 25/2017. The earlier writ petition, the petitioner had not claimed her candidature as PWD candidate. If in the present writ petition, the petitioner claims to her as PWD candidate having 45% hearing permanent in nature. Whereas the clause 7 of the general instruction for candidate states that OTET 1 past untrained SC, ST and PH category candidates can apply for city posts. It clearly indicates that candidate belongs to SC, ST and PH category who are untrained at the time of submission of application form can apply under untrained category. But in the instant case, petitioner applied under trained category having qualification BSc with BEd. This shows that the petitioner is a trained candidate. Option of application form. So the petitioner doesn't come under the purview of clause 7 of general instruction for candidate as far as advertisement. Pursuant to the direction,
what is they saying? Since she applied
differently
under the trained category.
Exactly.
Untrained category.
Having training qualification and a different OTET 2 qualification रखिଛନ୍ତି किंतु clause 1 रे OTET 1 रे apply करछନ୍ତି differently. बसों को कहते हैं बुझिबे
Yes,
my lord. That's why he was deprived of getting appointment. His candidature was rejected. That apart, my lord, it is a recruitment of the year 2014-15. 10 years before, in between, my lord, 2 to 3, 4, 5, 3 to 4 recruitments of Shiksha Saks have gone in between. Of every year, in each and every recruitment, the previous vacancies, whatsoever is there, is merged in the latter advertisement. There will be no vacancy even if there is a director.
Nobody retired.
No, that merges in the next recruitment. For 2014-15, he cannot be considered because of the wrong submission of application. So his case cannot be considered and writ application be dismissed.
Any reply?
Lordships, kindly come to my application, which I have received under RTI Act, page 30. 30. Lordship, got it, page 30.
Yes.
Lordship, on the heading application for the post of Shiksha Sahayaka, city. Since I have passed OTET 1, only I can apply under city category. Then Lordships, last column, reserve category.
Something placed in a trained list.
Yes.
They say they are noting placed in trained list. Then no city, physical handicap, untrained, because I marked it reserve category. Last column, before that, Lordship, ex-serviceman, reserve category, means physical handicap.
Where is that?
The Lordship, on the same left, reserve category. There is a reserve category, means physical handicap. There is no doubt that I have not applied.
No.
Sir, kindly bear with me. Sir, सब लिखा है जी जोड़ा देखा है. Kindly bear with me.
सेटा देखे दो, clarify करो. Page 30.
It is the reserved category. He has applied under reserved category.
Lordship, yes, he is right. But your Lordship may kindly have a look to first column. Age below SCBC category. Category is SCBC category. Lordship got it?
It is not properly xeroxed in my paper. What they have done is they have not done it from the beginning.
Lordship,
many parts are missing in this xerox copy.
Because they have got 600 pages of.
This page. Same thing. Could have
same thing.
That is
category SCBC is written, my lord.
Not PH.
Not PH.
But the PH is admitted. PH category is admitted in the earlier round of litigation.
My lord.
It is reflected in their selection list. Can you see?
In the selection list? Where is that? Where is that copy?
Copy, let's see. Yes.
No, is it part of the record?
Part of the record.
Here.
Let's see. Page 30, count it 30, 33. 33. Lordship, page 33, last line. Petitioner's name. Then category, hearing impaired.
Where is that hearing?
Page 33, Lordship. 20271, petitioner's name.
Correct.
Then Lordship. Yes. Second column, physical type. Second column, hearing impaired.
Hearing impaired.
Hearing impaired. On the top, it is written physical type. Means physical handicap, belong to which type?
Yes, Mr. G, it is under.
It is their document.
It's a selection list. He has been categorized under PH.
My lord.
But you structured your argument on the ground that she was not a candidate under PH at all.
No, I said, my lord. Yes, that is what.
Not you. For two reasons. Number one, you have already treated the candidate as PH. And in the earlier round of litigation also, the court itself said he is a PH category candidate.
Even if he is a PH category candidate, my sole contention now, my lord, I am confining it to the qualification he has acquired, my lord. He should have applied in that category.
Class 2 of the instruction.
Exactly. OTT 2. Instead of it is the general instruction that having BA BEd qualification cannot apply for OTT 1. OTT.
But what about class 7?
Class 7
of the instruction.
My lord. Class 7 of this, that is meant for on-trained candidates. And those who are not having training qualification, educational training, BEd or CT, it is meant for that.
That means untrained candidates are more favored than trained candidates.
My lord, because in the scheduled caste and scheduled tribe, there may not be available of trained candidates. That's why this provision is there. Engage them in their to fill up the posts of reserve category. OTT passed untrained CT, ST, PH category can apply for CT posts. It is there for only to favor them only.
PH also.
PH also is there if he is untrained. My lord, this is meant for OTT 2. OTT 2, my lord, paragraph.
No, 1 second.
My lord.
A trained candidate can be in a disadvantageous position compared to untrained candidate.
My lord.
Do you agree with the proposition?
My lord, I cannot. Again, my lord. A trained candidate cannot.
A trained candidate cannot be at a disadvantageous position for the untrained candidate.
No.
What you can give
no.
to an untrained candidate, cannot
be given, denied to
the candidate because he is trained.
My lord, I'm not. I can follow you, your lordship, my lord. My lord, no, I cannot. We cannot. But here the intention is to provide additional facility to the prescribed reserve category of people. This was done.
But he also fits into that category.
Yes, my lord. If he is within that category, if he could have applied in that category OTET 2, he can be appointed. He can get the appointment. But he has applied in the category 1, OTET 1. No. That is the fundamental mistake he has committed.
There is, in fact, a harmonious construction of instruction number 2 and instruction number
and 8 both. 7 and 8 both.
8. 7 and 8 has to be done.
This relaxation of educational qualification for a reserve category of people, it is there since long, my lord.
No, in that PH is also included.
Yes. It is there. He could have applied for category 1, not category 2.
If that were to be your case, where was the need for remanding the matter for reconsideration?
That I cannot say, my lord.
Third result. Yes. That is spend the time. Yes. I don't know. 50.
14. But may I please? In this case, the petitioner was a retired reader. He was not getting the final pension. Therefore, he approached this honorable court earlier. And this honorable court earlier directed for consideration of his representation. And that has been rejected under Annexure 3. On the ground that the vigilance has filed the final form. But in this case, vigilance has filed the final form and the exonerating the petitioner from the case, but the pension was denied, as per the rules 81, the pension was governed under the 81 rules, There is no
when the candidate retired,
31/8/21,
31/8/21
as reader,
How many years of
after
service?
35 years.
35 years.
The principal of the Kendrapada College, in which he was retired, his case was also recommended for granting pension. 6/6/23.
Now, no pension is sanctioned to you.
Only provisional pension 10,000 I am receiving.
Why? On what ground?
Ground, they have stated in the impugned order, that the criminal case is pending. They have admitted that the final form has already been submitted to the court. Final form acquitting the petitioner, exonerating the petitioner from the
petitioner is not set up for trial at all.
No,
his name is dropped.
Your lordship may see the page 27, page 26.
Now their ground is case is pending.
Right? Yes, brother. What do you think?
You have not filed counter.
Where is the question of counter now? If he is not set up for a trial at all after investigation, even if his name figures in the FIR, so where is the case pending against him? It is far better than acquittal. In acquittal, at least trial takes place. Now he is not set up for trial at all.
But the Honorable Court has to pass the final order.
What final order? Where is the trial of that person?
The instruction of the Honorable case.
Oh, I don't understand. Therefore, one should have knowledge of all civil criminal tax laws. Otherwise, this problem happens. In criminal law, if a person is named in the FIR, we can assume that he is accused loosely, because anybody can be named in the FIR. But the expression accused has a specific meaning. Therefore, under the service rules, a person becomes accused after the court takes cognizance of the complaint, if it is a complaint under 200, and if it is FIR, when the court frames the charges. Till then, he does not attain the status of accused in criminal jurisprudence, even in service jurisprudence also. Now, his case is far better than acquittal because he is not made an accused at all. Merely because police have named you, you do not become accused that way. The presumption of innocence continues with you. It is not shaken till the charge is framed. The famous judgment, which is the Hardeep versus, can anybody take 2014 Supreme? Hardeep Singh versus so and so. Which is that? Perhaps Hardeep Singh, it appears. So the question of trial will not arise at all. Hardeep Singh, I am not good in criminal law. Very few can decide in. Can anybody take out that judgment? 2014 Supreme Court. It's here. Yeah. This is the judgment which I just once read that. There, the question, idea of trial, all these things are discussed by the apex court. Of course, there are many old judgments which Kenny's criminal law, outlines of criminal law will say Smith and Hogan on civil criminal cases and material. They will discuss in English law. But this is the correct position. After investigation, then the police people that call it final report, which you call it charge sheet, though that word is not found in either in Evidence Act, IPC or CRPC. Still we understand that. They call it in North India, they call it a chalan. After investigation, they give entire investigated material to the court, magistrate court or jurisdictional court, saying these persons were named in the FIR, but after investigation, we found that only XYZ are the persons who can be implicated in this crime. That way, if the charge sheet says that his name is not there, where is sending him for trial? You have to release the pension. You cannot hold that way. Where is that charge sheet you have said mentioned?
My lord, your lordship may say page 27, my lord. The impugned order. Page 26, not from 26.
No, impugned order, all right.
My lord.
Where is the charge sheet which you are mentioning that you have not been named in the police charge sheet?
Impugned order indicated that.
That
indicate.
Where is that?
In page 27, in response to this department above mentioned letter, the SP Vigilance, Cuttack Division, Cuttack has reported that after completion of investigation, the case has been returned as final report of mistake of fact under section 13(2), 13(1)(d) and PC Act against the Ashok Kumar Rai, the then Director, Higher Education, the Ghanshyam Das, ex-Director, Higher Education Department, and the Pradipta Kishore Das, ex-Reader, Political Science, Auto College, Kendrapada. And final form.
Who Kishore Das? Who is petitioner?
Petitioner, Pradipta Kishore Das. My lord, final form 15 dated 30/4/23 has been submitted in the Court of Special Judge Vigilance, Cuttack. The case is posted for production of the document.
No, you are also named there.
My name, my lord, that is my lord, that my executive thing, my lord. Final report. Final report, my lord.
After completion of
investigation, the case has been returned.
Returned
as the final report. Mistake of facts.
What mistake of fact?
Under section 13(2), read with such and such and also.
Do you have a copy of final report? Can you produce one?
My lord, I will produce my lord. Your lordship may see they have instruction is also there, my lord. Vigilance Department instruction. Your lordship called for and they have to file, my lord.
Same, what is in the rejection order?
That is there, man.
No, the clarity is.
My lord, I will produce that.
You produce final report.
Final report, man.
Petitioner seeks time to produce a copy of final report stroke charge sheet for Chalan in the concerned criminal case. He has not been set up for trial. Okay. You also can procure that information. In this connection, the OPs are also directed to secure information and documents, copies of documents. Okay. Call this matter the third week of September. Yeah.
Item 49. May I please, Your Lordship? May I please, Your Lordship?
Yes.
Your Lordship, here the petitioner is a government work contractor. He completed the work within the stipulated period of time on 22/2/2024. Completion certificate issued in favor of the petitioner, but till
Bills
date
are not paid.
final bill lawful dues, which has been admitted by the authority, opposite party number 4, has not yet been.
Why, brother?
Notice was issued.
No, notice was served.
Notice was already issued.
Why final bill not honored? He wants his bill or what? Otherwise, there is no.
Your Lordship, may kindly say Annexure 1, page 12. It says everything. May I please, Your Lordship?
This is sent by
opposite party number 4, Superintendent Engineer, Baleswar, and 1.
Sent to Chief Engineer.
Chief Engineer. May I
saying that
may I please, Your Lordship?
has been completed in all respect.
Yes, my lord.
And handed over to concerned department.
Yes, my lord.
An amount of 34 lakhs been paid and balance of 68 lakhs is pending for payment.
Payment.
The NHM has issued allotment of rupees 51 lakhs by letter so and so.
Yes, my lord.
However, EPF authority recovered an amount of so and so from the so and so.
Yes, ma'am.
This amount 95 51 lakhs for about project. So forceful recovery of money by EPF authority has already been communicated to this. You have deducted that money also. You have deducted what is payable from the amount which is payable to him. But you don't want to pay the money. Your action of recovering from the amount which is payable amounts to admitting that so much amount is payable to him. Otherwise, you would not have deducted that portion. Ask your officer to be here.
Yes.
Generally, Apex Court said officer should not be called to court. But this is one case where he should be made to stand here.
Work is completed since.
There is something more than what I can meet. I means not I, EYE. I can meet. This is the percentage. It cannot be anything else. See, work is completed in all respects.
Yes, ma'am.
Amount is sanctioned by the beneficiary. Beneficiary has already sanctioned the money. You have compulsory deduction, statutory deduction, EPF, based upon the amount payable to him. But you don't want to pay that amount to him. This is too much. I will levy heavy. Let your officer not come here, but I will impose heavy costs. 10% extra he has to pay.
Let's call this matter next week. We shall come with the instruction, whatever.
Instruction, no. Check.
All right.
Instruction, what to instruction he will do with? Call this matter on Tuesday.
Tuesday, my lord.
All right.
Yes.
Yes, ma'am. Okay. Otherwise, I may impose 10% extra money. That will be around 6 lakhs, which the concerned engineer, chief engineer, has to make payment.
My lord. Yes.
or shall I restrain drawing of salary by the concerned office?
No, my lord, lordship may record that this will be the, if it is not released in his favor, then this will be the effect.
I will not record it because just tell him to look into our online proceedings. I will not record anything.
Lordship may not record anything.
It's available. This, you can tell
Yes.
it to see today's proceedings.
My lord,
It's available everywhere.
Yes.
ma'am.
Lordship, instead of recording anything, my lord, call this matter on Tuesday. I think I shall come up with.
Call on Tuesday at the This is too much. Yes, ma'am. We understand that these things happen, but how long? How can that is the reason why all the substandard work in all buildings, fan itself fell down in a brother judge's house.
Yes.
The fan mounted to the wall fell down, because part of the wall itself fell down because of these things. Yes.
Item 50.
Regarding RSC matter, my lord, your lordship passed the similar order. Yes. Opposite paper number 3.
3. You have rectified all these things. Have you changed the dates and other things?
MSCP money instead of MSCP, it will be RSCP.
No, we want to print just change the
Yes.
correction. Kindly correct. So just show it to Mr. Swain also once. At least he will. Pencil correction you have put.
Next item document
Covered by judgment.
Production
Print the scene. Just look it. Yes.
Item 51.
Yes,
Lordship.
Directly earlier order dated 13/8/2025. Paid post, my lord.
Some instruction, your lordship, as per the records that we had not. Lordship may call this matter some other date.
Because admission is going to be over by
short adjournment.
Tomorrow.
Yes, my lord. Because the second phase is started from 19th. Once
we give you time, but you should not plead that the time for admission is over.
By that process, they cannot get a seat in the better college.
Keep one
seat, your lordship, they will keep.
We have already kept it.
Yes, they will keep it in Malkanagiri because I am eligible to get it in SP Women's College in Cuttack.
Keep one seat in Cuttack College.
In Cuttack.
Yes,
yeah. Council learned, at the request of learned AGA, a period of 10 days is granted to file the objections.
You're not
subject to the condition that one seat in
any college of Cuttack, SP Women's College, Cuttack.
In any college in Cuttack shall be kept unfilled. SP Women's College, Cuttack, we can say that.
Anywhere, your lordship.
Any college.
Any college in Cuttack.
Any college. Okay.
Your lordship has called for the
SP Women's College.
Your lordship has called for the OMR seat.
Required?
Yes, ma'am. Because first the mark has been published at 49.67.
Requested to.
Your lordship already directed.
They already directed.
Yes, ma'am. They are
requested to comply with the order dated
13/8/2025. Your lordship directed to keep one seat vacant.
Yeah.
But it should be.
We have made it clear.
Yes, ma'am.
Yes. Oh.
Item 52.
Yes. Lordship may kindly see the last order.
Last order.
This person will obtain the instruction that is as per instruction 70 kilometers distance from the dialysis unity available at the new place.
That is 150 kilometers.
No.
The petitioner is a kidney patient. But may I suggest one thing?
Your lordship may see the order. Your lordship specifically directed.
Yes. Whether the facility of treatment is there or not. Petitioner is a
kidney patient.
Kidney patient.
Should be little.
Apart from this, there are other allegations against him.
Yeah, allegations.
He is a kidney patient, that is there. But being a government servant, he was participating in the protest against the government.
We'll advise him not to do that.
That also instruction. And
you advise your friend.
he has been, he is continuing in that post since last 13 years.
No.
So they are,
You are in that place since last 13 years.
No,
Post it may be different. But in
He became a regular teacher on 9/1/2020.
No, other day you said.
So prior to that, he was a Sikhya Sahayak and thereafter junior teacher. So far as Sikhya Sahayak and junior teachers are concerned, those posts are not transferable posts. Only a regular teacher is transferable.
You became regular teacher when?
On 9/1/2023, I have annexed that document that is under Annexure 2.
9/1/23.
9/1/23.
Retention period is?
Retention period is 6 years.
Mr. AGA, we'll instruct him not to participate.
Yes,
all that one.
Yes.
Number one. Number two, if it is a misconduct, hold the inquiry and dismiss him from.
Otherwise, it will be a punitive one.
that is.
You can hold inquiry. It will be a punishment transfer.
Somesh Tiwari's case.
Kindly be seated.
Yes.
Petitioner, a teacher in a government school, is knocking at the doors of Pit Court to call in question his transfer order dated
25th July 2025, Annexure 3.
25 July 2025 at Annexure 3.
Annexure 3.
Whereby he has been shifted from government UPS Pankadi
to government of
government UPS Jaladi. First term. Next paragraph. Learned counsel for the petitioner submits that although petitioner has been in the government UPS Pankadi for quite a long period, he became a regular candidate, employee, only with effect from 9/1/2023.
Yes.
And therefore, the retention period being 6 years, the same has to be reckoned from the date he became the regular employee. First up, he draws attention of the court to the transfer guidelines in this connection. First up. Further, he submits that petitioner is a kidney patient and that the place to which he has been transferred, the treatment facilities do not avail at. First up. That being the position, he submits, the government as a model employer has to be kind and petitioner be retained at the same place till he completes at least the retention periods. First. Next paragraph. Learned AGA appearing for the appeals vehemently opposes the petition, contending that the petitioner has been at the same place for about 13 years and that he has been participating in campaigns against government of that day. Semicolon. He also tells that the treatment facilities are available at a place which is at a distance of 70 kilometers from the government UPS, from Jaldi. Yes. Jaladi. First off. Lastly, he adds that a government servant has no immunity from transfer unless otherwise provided by, and therefore, in the light of Apex Court decision in Varadhara versus State of Karnataka, he should scrupulously obey the transfer order. First. Next person. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter, inasmuch as the petitioner became the regular employee only with effect from 9/1/2023. Yes. About the retention period of 6 years is not yet over. First off. Ordinarily, the transfer guidelines are adhered to inasmuch as they are held out to the employees of the kind, and that would create the legitimate expectation. The expectation, as rightly argued by counsel for the petitioner. First, to defeat legitimate expectation, stronger grounds are necessary, which are lacking in the impugned order. First off. Added is the kidney patient, and evidentiary material is placed on record to vouch the requirement of acute medical treatment, which facility avails at Pankadihi. First off. Of course, all such facilities to some extent may avail, as rightly contended by learned AGA, is of at a place 50 kilometers away from 70 kilometers away from Jaladi.
70 kilometers from Jaladi and 50 kilometers from Pankaj. That is the.
Anyway, Jaladi. Maybe true. First one. However, the medical treatment is a matter of faith. First, it is said. Who said that? The great Dr. William Bosler once said that it is faith that heals, and not the medicine. First one. Next paragraph. In the above circumstances, petition is favored. 7. The writ of certiorari issues quashing the impugned order of transfer. Annexure 3. At Annexure 3, coupled with the direction to continue the petitioner at the same place till he completes the retention period. Record from 9/1/2023. Yes. First off. One more round, the next round, one more, last round. The vehement submission of learned AGA that the petitioner has been engaging himself in anti-government campaigns, and therefore his retention at Pankadi is not desirable.
Yes. Anti-government protest as reported by Commissioner Rourkela Municipality.
as has been reported by the Commissioner of
Rourkela Municipal
Rourkela
Corporation.
Municipal
Corporation.
Corporation, be a ground for transfer of the time for two reasons. First off, under the conduct rules, ordinarily, the alleged activities amount to gross misconduct because that would affect the reputation of government of the day, which acts the government employees cannot be permitted to perpetrate. First off, no proceedings of disciplinary inquiry or of the kind are held in the matter. First off. Secondly, the transfer order does not reflect the same. First off, the Apex Court in Mohindra Singh Gill versus Chief Election Commissioner, AR 78 Supreme Court 851 observed that the validity of a statutory order has to be examined on the basis of reasons in the very same order and not those which come out dehorse it. First off, next but in the above circumstances, science. Court's ladies. However, the petitioner is advised and instructed not to give scope for allegations of the kind. Yes.
There is a ground has been taken.
But no reasons.
Administrative ground has been taken in the
Administrative,
yes,
but disciplinary ground is not.
There is a leading judgment on transfer, my lord. Safety post versus state of Bihar.
Supreme Court.
Yes. Versus state of Bihar.
Next matter, just 53.
You should halt the clock now.
No, I cannot. No, that is all what says. 53, I have been mentioning for last 3 consecutive times I have been mentioning. And this here in the matter, I am not getting salary since 2019, I am continuing. Only one lecturer. And the other person, he is a terminated employee. His instance, now continuing, I succeeded in the GI application that the tribunal, I succeeded. And just appeal is filed. And only because pendency of the application, I am not getting salary since 2019. Let's visualize my predicament. I file IA.
Salary is not.
IA is there.
I am appealing for the governing body. I am supporting him. But the concerned employee who is discharging her duties, she is not getting her salary because of the interim order passed by this Hon'Ble Court. And so far as
you appear,
since the case has been transferred to my office, I have the instruction to appear for the appellant in this case.
Appellant?
Yes, my lord.
So you appear for whom?
No, I am for the opposite party respondent. I am not getting salary. He lost in the tribunal.
Salary.
No, my lord, actually my difficulty is
he is not continuing. He is a terminated employee.
Today only I have this wakalatnama to appear for the appellant.
We'll call this matter on Tuesday.
Tuesday they will also call it an orders.
Some more.
So that orders discuss is there.
India is on 2nd of September.
Your lordship call any day on the orders.
2nd of September.
Under the heading of orders, lords. Let us say.
Put it in orders.
Orders, lords. On the heading of orders. Then not going to reach, not going to
it will reach at least.
Yes.
Item 54.
I shall file this wakalatnama on in
count 23. Item 56. So friends, all the responsible. Appellant.
Yes,
they will come on Thursday. So next Thursday.
This reform matter should take up because large number of people pending, and we also
since please Thursday only Thursday for appeal.
So the other matter may not taken up. Only the FO lots you can take up. So then matter can reach minutes.
One Thursday only FO.
Only FO, yes.
Otherwise these matters will not
reach minutes.
They have been pending since years.
Since years, yes.
Instruct office. Okay. Only
FO minutes. Thursday minutes.
Fresh admission on appeal.
Oh, FO category.
FO category, yes.
54 may be taken up, my lord, on 25.
Which matter?
54 item, next matter.
50. NC.
No.
Well, he is not getting pension because due to non-fixation of each salary.
2019 matter.
Yes, it will.
FAO.
46, well. Yes, but he is not getting pension and other due to non-fixation of each
Matters will come. Matters will come Thursday. Let it come on Thursday next.
Taken up my
2019 matter. Pension is not paid.
Not getting. I am not getting pension.
We'll call it on 2nd of September.
2nd of September. Yes, fine.
2nd of September.